Good afternoon, my friends. How's everybody doing? I hope everybody's doing well. Before I even get started, I want to give a shout out to Tom CPU, Jessica, um, Boston Mike, and Scott McGinnis, and all of the people who, like soldiers, like nothing less than soldiers, stood out in front of the Canton Police Department in honor of Boston police officer John O'Keefe, in honor of his memory, for 24 hours. It was snow. There was snow. It was cold. I am blown away by these folks right now. So yeah. Got to give it up for him, man. Absolutely. I am proud to be associated with those folks. Proud to support them. Proud to have their support. I am blown away just by things like that every single time they happen, because I just can't even believe that I'm part of something this amazing. So thank you guys for doing that. And a lot of stuff, man. Big bombshell that happened yesterday. Everybody went live about it, so I was like, all right, you know what? I'll go live tomorrow. And plus, there was the 24-hour standout, so I wanted to keep, kind of checking in on that. And I was welcomed on the panel for a little while last night, and I got to join them and talk to Dina. Dina was just amazing as always. And yeah, it was just great. But this news has not changed. And Aiden went over a great deal last night. He did a great job. I was in and out of the chat for that, but and I just realized, give me 1 second here, folks. Nancy, member for 8 months. Isn't there probable cause to arrest Jen McCabe? I think there's probable cause to arrest a bunch of people. The problem with that is, if it's going to be federal, and it's anybody who's properly building a case, anybody who plans on genuinely and justifiably prosecuting a guilty party, they're going to build a case. They're going to build an airtight case. They're going to collect enough evidence, basically the opposite of what you're seeing happening to Karen Reed. Basically the opposite. And this is one of the injustices. Talk time with Amy in Boston. Thank you so much. Appreciate you. Big shout out to you too. And there's Scott. Good to see you, buddy. Basically the opposite. What you want in a prosecution, when you want justice delivered, what you want is the opposite of what they're doing with Karen Reed, basically. Karen, like, if this is your first case that you've ever followed, and the first trial that you've ever followed, where you've actually paid attention and watched justice, and watched, well, not justice, but watched a court trial unfold, watch pre-trial motions, and watch the whole process happen. If this is your first case where you've done that, please educate yourself on other cases. Find something to contrast it up against, because the whole reason we're all here is because of all of the wrong that's happening. This is where it's all wrong. What any prosecution does when they're genuinely trying to deliver justice, the whole, going for the truth and not just a conviction, starts in the investigative process. And the investigative process starts with a first responder. Okay? With a first responding police officer. That's where the investigation begins. Now, what they're going to do when they are actually seeking justice, they're going to be in the mindset of this is going to end up in court. They're going to assume right off the bat that this is going to end up in court in trial. And they want to make sure that all of their I's are dotted and all of the T's are crossed. They're going to do this. Especially a detective, especially a lead detective. So what they're going to do is they're going to collect evidence, and 9 out of 10 times, what we would think is probable cause to arrest somebody is usually the only thing that is usually the thing that has made those detectives go, okay, this is our guy. And then they start building a case. Like, they might have enough to arrest right there and then. But 9 out of 10 times what they'll do is they'll let that person hang themselves. They'll get that person talking. They'll follow them and get their habits. They're going to do everything they can to present a case in court that convinces a jury beyond a reasonable doubt, where a jury goes, a jury can't be like, I'm not sure. I don't know. A jury's not going to be able to do that if you have provided a good enough case. And if you're going to do that, if you're going to provide a strong case, you're not going to just go for the most minimal of probable cause. Because think about the cases that get acquitted, right? It's usually some criminal that law enforcement has been trying to catch for a long time, and they couldn't get much on them, but they feel they need to get this person off the streets. So what they'll do is they'll just go with what, they figure is evidence, and it's enough evidence to convince the jury. But if that person has a good enough lawyer, they're going to go, I don't know. If that person has a good enough lawyer, sorry, it's distracted by something in chat. If that person has a good enough lawyer, they're going to be able to argue. They're going to be able to make the jury go, is that really enough? Does that make my client guilty of the crime that they committed? Are you sure about that? That's what they're going to do. And if that jury goes, actually, we're not sure. If one juror goes, actually, I'm not sure. I'm not sure enough to allow my vote to take away this person's life for the rest of their life. And that's usually what happens. The only time this doesn't happen, 99% of the time that this doesn't happen is because the prosecution and the officers, the law enforcement agents tasked with the responsibility of building a case, have collected evidence, piece of evidence after piece of evidence after piece of evidence after piece of evidence. It's like I've used this example before, The Departed. We're all big fans of Scorsese, right? We're all big fans of that movie. Takes place in Boston, right? And there's that part where Leonardo DiCaprio punches Mark Wahlberg in the face because he met privately with his CIs, or he's the CI, and Well, he's not a CI, he's undercover. But he goes to meet with Martin Sheen and Mark Wahlberg, which are the only two people that know that he's undercover. And he's scared because he's deep cover with a mob boss. So he's like, if they figure out who the fuck I am, they're not going to hesitate, but they're going to fucking murder me. I need you to get me out. Can't you just charge this guy? Like murder. The million fucking things. Remember DiCaprio goes, why don't you fucking charge this guy with the million fucking things you know he's done and that I could testify that I've seen him done? And Martin Sheen's answer is what? We're building a case. That takes time. You know that. Meaning that's shit that he learned from the police academy. That's what Martin Sheen's character is implying to DiCaprio's character in that movie, in that moment right there. Like, you know this. First case he's ever worked. Remember in the beginning, they're like, you're not a fucking cop. He's like, you sure about that? Remember that shit? Like, you already pretended to be a cop. You already pretended to be from Southie once. Do it again. And then Martin Sheen's like, do it for me. Right out of the academy. This dude has never testified in fucking open court. This dude has never written a police report other than to pass a grade. This dude hasn't done shit. And Martin Sheen is telling him it takes time to build a case. You know that. Think about it.
Oh, here we go.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare you?
Thank you so much. Let's see. Hold my halo. Okay. Norfolk County corruption is personal for me. This case is what gave me hope that they may someday be held accountable. Rest in peace, Mom. Rest in peace, justice for John O'Keefe, and free Karen Reed. I'm sorry. Whatever happened to your mom, I apologize. Or not apologize, but I'm sorry for your troubles. And I hope you do get justice. In some way, shape, or form. If justice for you is that those people are held accountable for another crime, well then absolutely. Now, this is so the prosecution can walk into a courtroom, give an opening argument, and go, you will see this, you will see this, you will see proof of this, and you will see proof of this. You will see video, you will see Celebrite data. You will see this, that, and the other. And you, when it comes time for you to walk back into that deliberation room, you will not have any choice in your own mind but to vote guilty. That's what a prosecutor's going to do. Yeah, that's not the real Aiden Carney. That's a troll, people. Relax.
Oh, here we go.
I think we got a super cat. Super cat. I think we got a super cat. Super cat. Super cat. Super cat. I think we got a super cat.
How dare you?
Stedeka, thank you so much. Why hasn't the defense challenged any of the Commonwealth's witnesses with Daubert hearings? I couldn't tell you. Maybe Daubert hearings are not a thing in Massachusetts. Maybe they are. I'm not a lawyer. I honestly couldn't answer that for you. There's a lot of things that the defense did in this last trial that make me go, why didn't they bring this up? Why didn't they bring that up? Why didn't they show this? Why didn't they talk about that? There's a lot of things, but I'm not an attorney, so I don't really feel comfortable criticizing Jackson and Yannetti and Little, and and I'm definitely not going to criticize Alessi yet because I haven't seen him do anything except for that one pretrial. So okay, let me just so this is absolutely 1 second. Sorry, I'm trying to do something that just can't wait. Unfortunately, I realize this is not something I like to do, but yeah, I don't even know, and honestly, I don't know what a Daubert hearing is. Um, so, but I do have confidence this time around. I have confidence that if Karen Reed's defense feels like they made mistakes last time, I'm sure that they learned from those mistakes. That's if they feel they should have done things differently. But I'm sure that this is new to them to deal with such a corrupt system. So I'm sure that they learned certain things from that experience that they're going to apply the second time around. I am sure of it. So yeah. Sorry, I'm looking for something and I'm not finding it. Give me 1 second. All right. Sorry. Give me 1 second. Let me work this out here. Um all right, let me try one more thing. So yeah, the whole idea that I mean, what we've been watching since we've been following this case is an absolute miscarriage of justice, meaning that justice is being miscarried. It means it's being mishandled. It means it is, and if justice, if you're thinking of justice as a baby, you're it's failed. It's gone. You miscarried it. When you're carrying it in your womb and you're trying to nurture it so is born a healthy baby, and you miscarry it, well, then that baby is no longer a thing anymore, is it? Right? So this miscarriage of justice is exactly that. Because the chances of even seeing John O'Keefe get justice are incredibly slim. Because I'm wondering, I don't know if because if you think about it, you have a lot of people here involved in this. And you have a lot of people that are involved in this. And if those people had this much time to tamper with or destroy evidence, I worry that this is going to ultimately cost John O'Keefe justice. All of this time wasted on Karen Reed and trying to railroad her, all of this time, all of this money, all of this energy could have been put towards figuring out exactly what actually happened to Boston police officer John O'Keefe and holding those who are responsible, holding those accountable. I love that you made that point, Microdots. You're saying Karen's not on trial as much as our system, in my honest opinion. That is 100% true. But the thing is that there's not enough people on this jury. Because what Microdots is saying here, at least what I think he's saying, is Karen's on trial, but since we know she's going to walk, we know that there's no jury in the world that's ever going to unanimously convict her with this sham of a case that the prosecution is presenting. There's absolutely no way. But as it's happening, the justice system in Massachusetts, in Norfolk County, are showing the world how they work. But the world's not looking. We are, but it's not enough. We're that jury. It's not enough. This is why we're trying to draw more attention to this case. This is why some of us are covering this case, because we want it to draw more attention. And the reason why we're trying to draw attention to this case as much as we are, to draw as much public attention to this case as possible, is because your freedom, your civil rights are at risk if this is allowed to happen anywhere in the United States of America. If you are an American citizen and this is allowed to happen, then your civil rights are at risk. This is what I'm doing this for. If you want to know why I'm doing it, it's for that reason, because I am a patriot. If I believed, and this is going to be an unpopular opinion, but so be it. If I believed that Karen Reed was guilty of this crime, I would still be sitting up here saying, let her go. Free Karen Reed. Why? Because one person who accidentally ran over their boyfriend, allegedly, because the Commonwealth can't figure it out. The Karen Reed haters can't figure it out. Did she kill him on purpose because she hated him? Or she did it by accident? Oh, because she's such a drunk. I would still be saying free Karen Reed, because one person because if anything, if there's even the slightest minute chance, which there isn't, that Karen Reed hit John O'Keefe with her vehicle, it was clearly by accident. She did not have an agenda. She is not a killer. If there was even the most minute chance that she actually did hit John O'Keefe with her vehicle, it had to have been by accident. So I would feel no remorse. I would feel I wouldn't hold back in the slightest bit in saying free Karen Reed, because her rights were violated. This is not how our justice system is supposed to work. They should have gone through the process of any investigation, followed the process of chain of custody, followed the process of interviewing witnesses, followed the process of wellness checks at 6 a.m. on January 29th. None of these things. Because if they can convict somebody with an investigation like that, then somebody who is innocent, that opens the door for anybody who truly is innocent. So Karen Reed, if she actually hit John O'Keefe with her car, that's a small price to pay to bring light on what's going on in Norfolk County and make sure that nobody ever walks again. But a person like Karen Reed walking free, small price to pay. Small price to pay. If she's actually guilty of striking him with her car, which we know that she is not. Because we know she's not. So, all right. Well, folks, I got to tell you, I have lost the affidavit. Let me try one more thing. Okay, no, I got it. All right. I've got it now. We're good. So we are going to go over this thing because Richard Green, who is an expert hired by Karen Reed's defense to prove that Jennifer McCabe's 227 search did happen at 2:27 a.m. Now, for those of you who don't know, which if you've been living under a cave, Jen McCabe's phone records indicate that she Googled "Haas long to die in cold" at 2:27 a.m. on January 29th, 2022, which is hours before Karen Reed found John O'Keefe laying on the lawn of 34 Fairview while Jen McCabe and Carrie Roberts were driving her around to look for her. Jen McCabe was in 34 Fairview Road that night. Left, if I remember correctly, according to her testimony and Matt McCabe's testimony, around 1 a.m., 1:30 a.m., something like that. I can't really remember. But there's a lot to this case. So, and shout out to my mods, Scott and Scott Messerschmidt. It's good to see you guys. Thank you, guys. Let me, sorry, I have to respond to. So, I promise. Well, I don't think there's going to be any more distractions. What's up, Street Squirrel? It's good to see you, buddy. So, if Jen McCabe Googles "house long to die in cold," and John O'Keefe, Boston police officer John O'Keefe, is found in the lawn where she was just hanging out earlier that night, and she Googles "how long to die in cold" a couple of hours after she had supposedly left his company, and hours before, she apparently didn't know where he was. But Googled at 2:27 a.m., "how's long to die in cold," when Boston police officer John O'Keefe is found dying in the cold at 6 a.m. that morning. Explain that one. So, the Commonwealth, in order to railroad Karen Reed, tried to say that this didn't happen. She didn't Google at 2:27 a.m. She actually Googled under the behest of Karen Reed herself at 6:30 a.m., 6:34 a.m. to be exact, under the behest of Karen Reed herself to Google this in a panic. Karen Reed denies asking her to do this. Yeah, it was a butt Google. Thank you, Meme Life. So Karen Reed, of course, denies this. And so, of course, there's no other witnesses to this. Conveniently for Jen McCabe, because she's not the one on trial. But that 2:27 a.m. search convinces me that she should be. Now, not charged with the first-degree murder of John O'Keefe or even the second-degree murder of John O'Keefe. I don't really know how that works. But the involuntary manslaughter, no, that doesn't apply, because that means that she had the intention with that Google search at 2:27 a.m. of leaving Boston police officer John O'Keefe out there to die in the cold, and was concerned with it maybe taking too long, because she was concerned with him waking up, and she was concerned with him having the ability to point fingers. So, everyone believed that he was dead. They left him out there. At least this is my theory. But they weren't 100% sure that he was dead. But close enough. Probably couldn't feel a pulse. And so, just to be thorough, Jen McCabe is like, well, there's no way he's going to survive that if we just leave him out there anyway. So I better find out, just for my own peace of mind, how long it's going to take him to actually die in the cold if the injuries that were left on him don't kill him. That's my theory. But I am absolutely convinced that Jen McCabe Googled how long to die in cold at 2:27 a.m. on January 29th, 2022. And if she did that, that means that she intended for him to die out there in the cold, and that is murder, and that makes her a cop killer. That makes her, in my opinion, now that may not be how the law works, but that makes her, in my opinion, just as culpable as whoever hit him in the head. Just as. Okay. So here we've got the defendant's opposition to Commonwealth's motion to exclude certain testimony of defense witness Richard Green. Now comes the defendant Karen Reed, Miss Reed, and respectfully requests that this honorable court deny the Commonwealth's motion to exclude the expert testimony of Richard Green as to sorry, got a response that I was waiting for here. Now comes the defendant Karen Reed and respectfully requests that this honorable court deny the Commonwealth's motion to exclude the expert testimony of Richard Green as to his expert opinion that a Google search for how long to die in cold or how long to die in cold was made on Jennifer McCabe's phone prior to 6:23 a.m. on January 29th, 2022. And his expert opinion that Jennifer McCabe's phone incurred user deletions of any data related to Google searches and deny the Commonwealth's included request for an evidentiary hearing under the standards set forth in Daubert versus Merrill. Okay, so I'm seeing that word Daubert again. Okay. The Commonwealth has not made any showing that the qualifications or methodology of Mr. Green do not satisfy Daubert-Lanigan. Instead, the Commonwealth's entire motion merely addresses the conclusions and opinions of Mr. Green. Matters that courts resoundingly state are the subjects for cross-examination and the jury, not the narrow function of the Daubert-Lanigan judicial gatekeeper. Moreover, as this opposition clearly demonstrates, Mr. Green is eminently qualified and his methodology pertaining to the subject matter of the instant motion is reliable. As a result, in addition to denial of the motion, no evidentiary hearing is justifiable. The motion of the Commonwealth to exclude a trial testimony of Richard Green is just the latest in the Gatling gun. Dystopian approach of the Commonwealth to deny Miss Reed the ability to present her defense through well-credentialed methodology, reliable expert witnesses, so she can have a fair trial against the baseless charges lodged against her. Now, I love that shit. That is some wordsmith shit right there. I love this. I'm going to read this again because the impression that I'm getting off of that piece that I'm reading right here, the impression that I'm getting from this is the gloves are off. The defense is clearly on to Brennan's strategy here, and Brennan's strategy is to rob Karen Reed of a defense. That is his goal. Make absolutely no mistake about that. What he's doing is trying to rob Karen Reed of her defense. And this, when you are patriotic Americans, which a lot of defense attorneys are. Very patriotic. This is going to piss you off. This is going to piss off an attorney like Alan Jackson or David Yannetti or Eliza Little. This is going to make them mad. Because here they are defending a client, defending her rights, and I don't think that they've ever had a case that they've dealt with where a client's rights were robbed so much, so consistently by so many different players. Now I'm going to read that part one more time. This is amazing to me. Listen to the craftsmanship of these words. The motion of the Commonwealth to exclude the trial testimony of Richard Green is just the latest in the Gatling gun dystopian approach. Dystopian like the Mad Max franchise is described in its synopsis as a dystopian world. Meaning there are no rules. Meaning I change the rules whenever the fuck I want. I do whatever the fuck I want. If you got it and I want it, I'm going to do whatever I can to take it. And that is fair in this lack of society. Think about that. That's a beautiful word to use right there. Children of Men, also a dystopian film. Basically any zombie movie. Any movie where there's been a zombie epidemic for like the last 10 years is a dystopian society. So a dystopian approach of the Commonwealth to deny Miss Reed the ability to present her defense through her well-credentialed, methodologically reliable expert witnesses so she can have a fair trial against the baseless charges lodged against her. See, they're not holding back. They're not. They're like, dude, baseless charges. You have fucking nothing. Hank Brennan has nothing. It's simple. And this is all Michael Morrissey pulling these strings. And for some reason, Bev is just paving the way for it. The judge. It's craziest shit I've ever seen. The expert witness of the defense here, Richard Green, testified as an expert witness in digital forensics in the first trial regarding his opinion that the Google search "Huss Long to Die in Cold" existed in the data from the iPhone 11 of Jennifer McCabe with a timestamp of at or before 2:27:40 a.m. 2:27 and 40 seconds a.m. and in a deleted state. This is very important. In a deleted state, 2:27:40 a.m. search artifact without any objection from the Commonwealth as to his qualifications or methodology, and for good reason. Mr. Green has been accepted in several United States courts as an expert in digital forensics. The methodology that Mr. Green employed in the first trial was the same methodology that the proffered experts of the Commonwealth employed. That is, Mr. Green and the two proffered experts of the Commonwealth received the same raw image file from Jennifer McCabe's iPhone 11, verified the hash signature, value of the image file, took the image file and saved it to their computer server's hard drive, etc., and then processed and evaluated the image file with the appropriate tools such as Cellebrite Analyzer and Magnetic Forensics Axiom. While Commonwealth witnesses sorry, while Commonwealth witness Ian Whiffen used only the Celebrite physical analyzer and ArtX tools, Commonwealth witness Jessica Hyde historically used 3 more tools than Ian Whiffen, and Richard Green used at least as many tools as Jessica Hyde, and Green and Hyde using 4 of the same tools. Notably, although Jessica Hyde previously used 4 of the 5 tools used by Richard Green in her initial analysis, all but Celebrite are now disconcertingly absent from her December 2024 report submitted with the Commonwealth's motion, despite her admonitions in her previous reports that it is best to use multiple tools. So what they're saying here is Jessica Hyde used 4 out of the 5 tools used by Richard Green. 4 out of the 5 tools used by the defense's expert. One of the Commonwealth's experts used 4 out of the 5 is the same as the defense's expert in her initial analysis, the first time she did the analysis. And now all but Celebrite are absent. Every single one of them from her December 24 report. That's crazy. So from her most recent report, all of those other things except Celebrite have been taken out of her entire analysis. All of those tools gone. And even though she said in the initial report that it was best to use multiple tools. Think about that. So right there, we've got the Commonwealth's expert being inconsistent and acting shady. Importantly, it was undisputed by all expert witnesses at the first trial that the 2:27:40 a.m. search artifact was indeed present on the iPhone of Jennifer McCabe after analyses using Celebrite physical analyzer forensic technology available and on the market at the time. It is thus completely inexplicable how the Commonwealth can now challenge the methodology of Richard Green, whose methodology is the same as and then more comprehensive than that of the digital forensics witnesses of the Commonwealth. Right. Like, how can they challenge it? It makes no sense. It is the opinions and conclusions, not the methodology of the witnesses that differ, but that the difference is not a Daubert-Lenigan issue. Now, I would need an attorney to explain that better. They're saying it is the opinions and conclusions, not the methodology of the witnesses that differ. But that difference is not a Daubert-Lenigan issue. Okay, so I think I understand. So they're saying that the conclusions and the opinions, they followed the same exact process. They followed the same exact process, used the same tools, but came up with different opinions, different conclusions. And so they're saying that that difference is not a Daubert-Lenigan issue. Now, I still don't understand what the Daubert-Lenigan issue is, what that defines fully. Again, I'm not a lawyer. I'm sorry. I couldn't explain that better. But saying that is where this is what they're using as a leg to stand on legally here. What has changed since the first trial? The answer is disturbingly Orwellian. I love that shit. The answer is disturbingly Orwellian and brings the prosecution closer to, if not squaringly within, the danger zone of legal tyranny. After the first trial, the proffered expert witness for the Commonwealth, Ian Whiffen, a law enforcement-centric digital forensics consultant, appears to have gone back to his company, Celebrite, to his company Celebrite to have its researchers perform further updates to its physical analyzer program such that the artifact containing the 227 timestamp has now suddenly disappeared from all Celebrite programs. Wait, what? After the first trial, the proffered expert witness for the Commonwealth, Ian Whiffen, a law enforcement-centric digital forensics consultant, appears to have gone back to his company, Celebrite, to have its researchers, in quotes, perform further updates, also in quotes, to its physical analyzer programs, such that the artifact containing the 227 timestamp has now suddenly disappeared from all Celebrite programs. So once this dude went back to Celebrite after the trial, Celebrite, all of a sudden, you can't even see the 227 search in Celebrite at all anymore. That's interesting. After Ian Whiffen went back for updates with Celebrite, with his old company, this is fucking crazy. You know how many times I've seen Celebrite convict someone on trial? You know how many times I've seen that happen? This is crazy. What has changed since the trial? The answer is disturbingly Orwellian and brings the prosecutor close to, if not squarely, with the danger zone of legal tyranny. The 227 search artifact is now nefariously become, without explanation, the Orwellian unperson. Now, if I had to guess, that's probably a quote from 1984 or a reference to 1984, which I have never read, so I don't fully understand the reference. I started to read 1984 when I was a kid. I did not have the patience for it. That's the difference between my brother and me right there. My brother is the smart one between the two of us, and he was, I believe, reading 1984 in the 5th grade, I think. And then I tried to read it in the 7th grade, and I couldn't pay close enough attention to stay interested. And I started to watch the movie, and I never even finished the movie. I think that's just an ADHD thing. Seriously, I think that's all it is. Because I started to watch the movie. That's the one with John Hurt, right? I think it's John Hurt. Am I confusing John Hurt with William Hurt? No, I'm doing that now. John Hurt is the English guy. John Hurt's the guy that was in 1984, as well as The Proposition with Guy Pearce that was written by Nick Cave. And yeah, John Hurt. He was in that movie, right? Sorry, I'm totally now I'm just stuck on this. Yeah. Yeah, in The Proposition, he was like, "We are white men, sir. The flies are crawling." Great movie. Yeah, John Hurt was also Elephant Man. That's right. David Lynch, who, rest in peace, just recently passed. After Celebrite completely rid itself of the 227 search affidavit that is incredibly inconvenient to the theory of the case of the Commonwealth, incredibly inconvenient to say the least, author of this motion, the Commonwealth now comes before the court saying the unilateral and unexplained Celebrite updates to remove the 227 AM search artifact should control whether a jury is able to evaluate whose digital forensic theory about the artifact is most accurate. And in doing so, glaringly, the Commonwealth does not address the other forensic tools, such as magnet forensics axiom that Ms. Hyde used in 2023, that Mr. Green used in the first trial and continues to use up to this day, and still contains and shows the 227 search artifact, nor the several other digital forensics tools that Mr. Green used. Fascinating. Additionally, the motion of the Commonwealth is legally insufficient on its face. The motion is not supported by one affidavit. The motion does not even begin to meet its going forward obligation to state how Mr. Green is now, suddenly after the first trial, supposedly not qualified. Nor does the motion even begin to identify what the Commonwealth believes is the proper methodology to address the 227 search artifact, or why the methodology employed by Mr. Green to analyze it is not reliable. Okay, so I think I understand now a little bit better. So they can't say that this is what I'm saying is, and this is what the defense is saying. How can the Commonwealth claim that Richard Green is not qualified when he employed the very same tools and very same methodology and the very same process that the Commonwealth's experts used to analyze Jennifer McCabe's phone, to analyze the 2:27 a.m. artifact? If they employed the very same process, the very same tools, the very same methodology, why are they trying to say that he's not qualified? If he's not qualified, then they're not qualified. If they use the same methodology and tools, were they sitting next to each other and was Richard Green going, hey man, what do you got for number 3, bro? No? Come on, man. She's not even looking, dude. What do you got for number 3? You think that's what Richard Green was doing? Think Richard Green was going, hey, man, so what'd you use to, because I'm on there and I don't really see. Can we get Jessica on the 3-way call? Because I'm trying to figure out how you guys are doing this. What? I don't understand. Okay. So I go here and I go here and I go here. Oh. Okay, I'm doing everything you said, but it's still coming up that Jen McCabe did the 227 search. I'm coming up with the 227 search. You're saying it's not there. I'm doing the same thing you're doing. That's not what happened, dude. My man went his way. They went theirs. Just so happened that they used the same exact methodology and the same exact tools. Then later on, Jessica Hyde, in December of 2024, after the trial ended, the first trial ended, puts in a report that she only used Celebrite as a tool, even though her initial report stated that it's wise to use multiple tools, more than one. Tell you troubleshoot. So then this also happens after this Ian Whiffen dude goes back to Celebrite and does these updates. And then there's no more Celebrite. There's no more 227 search stamp on the Celebrite data at all. At all. So that's real convenient, right? Just so I don't skip anything, I'm going to read that part one more time. Additionally, the motion of the Commonwealth is legally insufficient on its face. The motion is not supported by one affidavit. There's a lot of snark in here, and it's not really snark. It's just like really, really well worded. It's just super bold, and the boldness is a bit snarky, and I love it. The motion is not supported by one affidavit. The motion does not even begin to meet its going forward obligation to state how Mr. Green is now, suddenly after the first trial, supposedly not qualified. Nor does the motion even begin to identify what the Commonwealth believes is the proper methodology to address the 227 search artifact, or why the methodology employed by Mr. Green to analyze it is not reliable. Perhaps this failure is due to the fact that Mr. Green is eminently qualified, including more qualified in data forensics than Mr. Whiffen, and that the methodology Mr. Green employed includes the same and entire methodology of the proffered witnesses for the Commonwealth, plus his addition of additional accepted digital forensic tools. To prevent the continued abuses of Miss Reed by the Commonwealth, including the bleeding of her financial resources and distractions from her and her defense team's preparation for trial, the invasion of the province of the jury. Now, I want to read that again because I love this shit. This is them just being like, I'm sick of this shit. Love this. To prevent the continued abuses of Miss Reed by the Commonwealth, including the bleeding of her financial resources and the distractions from her and her defense team's preparation for trial, the invasion of the province of the jury, and other broader jurisprudential maladies, this court must deny the Commonwealth's motion and its included request for an evidentiary hearing. They didn't request. They said this court must deny. Case history of the digital forensics analysis of the 227 AM search artifact. For 3 years in this case, there has been no dispute over the methodology employed by the defense to address the issue of 227 AM search artifact. On June 21st, 2024, Richard Green testified at the trial as a defense expert without any objection as to his qualifications or methodology. The use of digital forensic tools to analyze data on the raw image file. As he stated in that testimony, after receiving the raw image file of the data contained on Jennifer McCabe's iPhone 11, Mr. Green used 5 digital forensic tools to evaluate and analyze the data on the image file. Celebrate Physical Analyzer, Magnet Axiom, Belkasoft FTX, Sanderson Forensics, XQ Lite, Forensic Explorer, and ArtX. Blah, 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 blah. Though through the use of these 5 tools, Mr. Green found that the 227 AM search artifact existed and appeared in a deleted state. Okay? In a deleted state. This is very important. Keep that in mind. These findings were consistent with the April 24, 2023 report of Trooper Nicholas Guarino. There we go. Right there, folks. We always keep hearing Guarino's name, Mr. Oh, Kill Me, on a hot mic. Trooper Nicholas Guarino, who testified as a proffered expert of the Commonwealth in the first trial. Mr. Guarino reported that while the 227 AM search artifact did not appear on the version of Celebrate Physical Analyzer, he had used for his May 4th, 2022 analysis of Jennifer McCabe's iPhone data. Blah, blah, blah. Mr. Green had used the then newest version of Physical Analyzer, which did depict the 227 AM search artifact. Sorry, there's a lot of references to cases, and I'm trying to skip them and not miss other stuff. We don't need to hear the timestamps of the other trial and when this stuff was testified and on the record. That we don't need that. Inexplicably and unexplained up to this day, Trooper Guarino did not disclose in his report of April of 2023 that the Axiom program he used at that time did show the 2027 AM search artifact. Wow. Mr. Green's findings were further consistent across all 5 tools that he employed. Now, doesn't that tell you something? Doesn't that tell you something? This dude employed 5 tools. The same 5 tools employed by the Commonwealth's experts. The defense's expert employed 5 tools. He came up with the same analysis every single time. He came up with the same conclusion using 5 different tools that supposedly do basically the same thing. Came up with the exact same thing. But for some reason, there's inconsistencies in the tools used by the Commonwealth's experts and the tools used by the Commonwealth's experts versus the conclusions that the Commonwealth experts have come up with. There's inconsistencies in the Commonwealth, again, in their investigation, whereas this is completely consistent coming from Richard Green, the defense's expert. This is someone who employed 5 different tools and came to the same conclusion. If you employ 5 different programs to try to investigate a simple thing, if you take 5 different avenues following clues to get to an existing location, and all of those avenues lead you to that location, well, then that location's there. It's not a figment of your fucking imagination, is it? You're standing right in the fucking middle of it, and you took 5 different roads to get there. But if the Commonwealth takes these different roads and ends up in different places, well, then they must have some bad information, or their tools must be flawed, or they don't know how to use them. Or, this is going to be a controversial idea, they're completely full of shit.
Oh, here we go.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad.
How dare you?
Period, full stop. Thank you so much. CW Commonwealth trying to conflate probabilities. What's the probability it's raining because it's cloudy is not the same probability it's raining because it's cloudy. Exactly. 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 I completely agree. Now I'm gonna refer back to chat here and there for a minute. Because this is some crazy shit, and I really am interested in what you guys think about this stuff. True Crime Addict, member for 3 months. I've been here longer. Thank you so much. Appreciate it. Yeah, I know, Ask Bob. I know. I streamed it live. We were all here for it. Thank you. Appreciate it. If you change the grid you're measuring with, the outcome will be different. I mean, it just doesn't make sense. Like, it's fascinating to me that this is, I mean, is it, how many coincidences are there where we're seeing a tactic by the Commonwealth that's commonly used by the defense, which is to do what? Provide inconsistencies that do what? Confuse the jury. And the purpose of this is to do what? Create doubt. Why are they creating doubt? Why not just prove that Jennifer McCabe did not do the 2:27 a.m. search? Or why not work around it? Because the thing is you can't prove that she didn't do the 2:27 a.m. search because 5 different programs have concluded that she did. Not just Celebrate, but 5 other ones concluded that she did. And I've discussed this concern in the past as well, because we've talked many times about how many times I've seen Celebrate used to convict someone on trial, someone who actually was guilty, right? So I've seen this a bunch of times, seen this many times. And I find it interesting that the Commonwealth is going to rely on Celebrate data to convict Brian Walsh, who also had Trooper Michael Proctor as the lead investigator in that case. So how are they going to do that? Because this is my main concern. My main concern, and I guess another company will pop up. I don't think it's that big a deal. Another company will pop up, but Celebrate's got a great track record. And it sucks for Celebrate that this employee, for some reason, had a gainful interest in promoting his own company by discrediting Celebrate data. And the Commonwealth is going to use this. And I wonder how many cases in the future this is going to affect Celebrate's credibility. And I wonder if this is going to affect Brian Walsh's conviction. Because I believe Brian Walsh is absolutely guilty. I believe Brian Walsh absolutely killed his wife. 100%. Because I trust Celebrate data. I always have. Or at least I have long enough since I've seen it convict more than one guilty defendant. So now I'm worried that Celebrate won't be reliable anymore. But mainly I'm worried about, because like I said, I mean, another company will pop up, build some credibility. It'll be whatever. But look at all the credibility that Celebrate has already built. Just in the true crime community, just in the public eye. But what I'm mainly worried about is Brian Walsh walking free. That's what I'm mainly worried about. Gem Girl's saying the only certain thing they'll be able to say, the information is too shaky, causing confusion. That's the worst. Best case, she did search it up. Best case, she did search it up. I mean, but she did. Yeah, exactly, Kayla Jones. That's what I'm worried about. How many cases are going to refer to this? Think about the mark this does on the system alone, the mark that this leaves on the system alone. Think about how many defense attorneys with guilty clients are going to use this case and twist certain things that have taken place for their benefit that could free a guilty defendant because of the misconduct and the misappropriation of methods applied by the Commonwealth of Norfolk County, or the Commonwealth of Massachusetts and Norfolk County. Think about that shit. That's why this is so important. That's why I'm here doing this. Because I sure as shit don't want to get stopped, thrown in a fucking jail, and have all my rights violated. And for some reason, it's okay. Because that right now is happening to Karen Reed. Luckily, she had the means for bail. Oh my God. Yeah, this is why this is a big deal, people. Why do you think that Turtle Boy's doing everything that he's doing? Why do you think Turtle Boy sat in jail for 2 months when he could have just taken a plea? Why do you think he did that? This is bigger than Karen Reed. And yes, it's even bigger than John O'Keefe. Yes. This is about your rights. This is about the fabric of the American justice system being fucked with. This is dangerous for every single person in this chat who lives in this country. And every person who's in this chat who's in another country whose justice system emulates ours, whose justice system is inspired by our own. This is dangerous for fucking everybody. Mr. Green's findings were further consistent across all 5 tools that he employed. And remain consistent with findings as of January 25th from analysis performed in the most recent version of Axiom, which continues to report the 2:27 a.m. search artifact. Oh my God. Like Mr. Green, Mr. Whiffin's methodology was to use digital forensics tools to analyze the raw image file of data from Jennifer McCabe's iPhone. Unlike Mr. Green, however, Mr. Whiffin used only 2 digital forensic tools in his analysis of the data: Cellebrite Physical Analyzer, his company's tool, and ArtX. After performing an analysis using a then on-the-market Cellebrite Physical Analyzer program, Mr. Whiffin testified at the first trial and reported that he had seen the 2:27 a.m. search artifact. Jesus, dude. Timestamp was a blah, 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 blah. It was indeed a deleted record. Timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. Wow. Thus, while he disagreed with Mr. Green's opinion about whether that information indicated a search for How Long to Die in Cold was conducted at 2:27 a.m., he did not dispute that this 2:27 a.m. search artifact was present and in a deleted state during his analysis. Whiffin did not dispute this. Jennifer Hyde also employed this methodology, originally using Cellebrite Physical Analyzer, Sanderson Forensics, Axiom, ArtX, and iLeap. 4 of these tools were among the 5 used by Mr. Green in his analysis. In her May 2023 report and in testimony at trial, Ms. Hyde agreed with Mr. Green and Mr. Whiffin that she had seen the 2:27 a.m. search artifact during her analysis. With the timestamp 2:27 a.m. was marked by Cellebrite as having the testimony and being deleted. Okay, so in Oppen X, wait, hold on, I'm reading this wrong. This is confusing shit because I don't know anything about phones or tech. Yeah, she had agreed. Okay, so Miss Hyde agreed with Mr. Green and Mr. Whiffin that she had seen the 2:27 a.m. search artifact during her analysis. She also admitted in her May 2023 report that the 2:27 a.m. search artifact appeared in a deleted state. So Ms. Hyde even said that it appeared in a deleted state. She disagreed with Mr. Green's opinion about whether this information indicated that a search for Haas Long to Die in Cold was conducted at 2:27 a.m., but she did not dispute that the 2:27 a.m. search artifact was present during her analyses. Inexplicably, Ms. Hyde changed her analysis and findings from her May 23 report to align with Mr. Whiffen after a Celebrite manipulated update to one physical analyzer program. One, not five, not four, but one, being Celebrite. So she changed her analysis after this update was done. Wow. Which the defense learned about approximately 1 week before trial began, magically removed the 227 timestamp value from records sourced by the Safari's browser state. Blah, blah, blah. Using this updated Celebrite tool and no others, Ms. Hyde drafted a new report in December 2024, taking back without explanation her original conclusion that the artifact containing the 2:27 a.m. timestamp was present on the phone of Jennifer McCabe in a deleted state. She opined instead that the artifact containing the 2:27 a.m. timestamp was not present in a deleted state or otherwise, citing merely an unsupported conclusory and scientifically insufficient assertion that the timestamp was not reliable. Yeah. And it gives you the shit to compare. And here, I'll share the link. If anybody, just so this never happens again, here's the link to, I hope it's small enough to go through. Yeah, there's the link to what I'm reading right now. If anybody wants to hold on to it and read it for themselves, because I'm doing a terrible job at reading it. Like Mr. Whiffen, neither Ms. Hyde nor the Commonwealth explain how the update occurred or in any scientific reason for the change. The Commonwealth simply makes the same bald, conclusory statement as Ms. Hyde that further research shows, and this is in quotes, further research shows that the timestamp is not a reliable source for a timestamp relating to the URL shown, without any viable explanation to follow it. The Commonwealth provides no explanation for that assertion, nor does it provide any information as to the reasons why that supposed research allegedly finds the 2:27 a.m. search artifact. And this artifact alone to be unreliable. It also sorry, let me read that sentence again. The Commonwealth provides no explanation for that assertion, nor does it provide any information as to the reasons why that supposed research allegedly finds the 2:27 a.m. search artifact and this artifact alone to be unreliable. It also provides no information about the methodology of the research or any other information regarding what changes were made, how or why. Critically, despite the manipulation associated with the unexplained update and the accompanying sudden change in the analysis of the Commonwealth's proffered experts, Ms. Hyde's second report dated December 2024 does not represent a different methodology, but rather a narrowing of and change in opinion about the presence of the 2:27 a.m. search artifact. That's interesting. So in her December 2024 report after the trial, it doesn't represent any different methodology, but it changes her opinion about the presence of the 2:27 a.m. search and artifact. In the second report, she employs the same methodology as she did in the first trial. And as Mr. Green and Mr. Whiffen employed but deletes mention of an inconvenient axiom tool she used in her May 2023 report, which as of the date of this opposition continues to show the artifact containing the 2:27 a.m. timestamp in a deleted state. To reach a different conclusion, the only difference in fact between the application of the methodology, hold on, before I start that, let's just do a quick Cliff Notes recap of what fuck is going on here. Let's do that real quick. 5 different programs used to reach the very same conclusion. By all 3 experts. Well, one of them used 4 out of the 5 programs, right? 4 out of the 5 same tools. And Dawn by the River gifted 5 memberships. Thank you so much. Oh my God. You're amazing. Thank you. Now, they used, this is the Cliff Notes here. Basically used the same methodology initially, but surprise, surprise, the defense comes up with a different, the defense's expert comes up with a different conclusion than the Commonwealth's experts. Now, then, after the trial, another report is submitted by the Commonwealth's experts in December of 2024. Another report is submitted. And after this report is submitted, or once this report is submitted, this is right after Ian Whiffen supposedly went back to Celebrite and deleted any trace of the 227 search in the Celebrite data. And so in both of their and now they're only employing Celebrite. They're only using Celebrite. They're only saying and going by whatever the Celebrite data says. But the defense's expert, David Green, or Richard Green, excuse me, I don't know why I said David Green. Richard Green, he employed 5 different programs, reached the same conclusion that the 2:27 a.m. search happened. At 2:27 a.m., the House Long to Die in Cold search happened at 2:27 a.m., according to 5 different programs and 5 different tools that Richard Green used. And do you think Richard Green was trying to eliminate? He's trying to figure out, how could it not be there? Is there some sort of flaw? What's going on here? That's why you employ the other tools. Is there a flaw in the tool that I'm using right here? Is this why they're coming up with a different conclusion? So what do I do to make sure that this tool that I'm using isn't flawed? Well, I'm going to apply other tools. That's what he did. He applied other tools, came to the same conclusion. But conveniently enough, he reaches the same conclusion initially. But initially, which was acknowledged by both Ms. Hyde and Mr. Whiffen, they both concluded initially that a 2:27 a.m. search popped up and that it showed up as deleted. But now all of a sudden they're saying no, that never happened. While only employing Celebrite now. While only applying Celebrite as their tool. And this is after Ian Whiffen, who works for Celebrite, goes back and does an update. Okay. The only difference, in fact, between the application of the methodology by the Commonwealth's proffered experts and the application of the methodology by Richard Green is that the former is entirely encompassed by the latter. Mr. Green simply used more tools in employing the same methodology, and thus was able to conduct a more thorough forensic data analysis. It's a more intelligent way of explaining what I just did. The appropriateness and reliability of Mr. Green's all-encompassing methodology is evidenced by the fact that all experts agreed and opined at some point during the first trial that the 2:27 a.m. search artifact existed. That it existed and appeared in a deleted state. Mr. Green's methodology is further supported by Jessica Hyde's testimony that it's important to use multiple tools so you can see the results from different data sets and be able to compare those results and enhance those with manual analysis. So the very same person who says this initially before the first trial says it's important to use multiple tools to get a reliable analysis. And then in her December 2024 result analysis, she only uses Celebrite and says, I didn't see nothing. 2:27 a.m. search, didn't see it. Nothing. Period, full stop. Thank you so much. 4 out of 5 dentists recommend, but 1 asshole dentist. Exactly. And that doing so is absolutely pertinent. So not only using different data sets, it's important to use multiple tools so you could see results from different data sets and be able to compare those results and enhance those with manual analysis. And that doing so is absolutely pertinent and allows her to ensure that she's getting the most complete interpretations. This mimics the approach of Mr. Green and is counter to the myopic and company biased approach of Mr. Whiffen, to which Miss Hyde now disquietingly has morphed. The experts' disagreement is not over the methodology, but rather their opinions on whether the 2:27 a.m. search artifact indicates that Jennifer McCabe conducted a search for how long to die in cold at or before 2:27 a.m. Contrary to the assertion of the Commonwealth, this is paradigmatic battle of experts. And that's what the trolls keep saying. And the fence riders say, well, it's going to boil down to a battle of experts. It's going to boil down to a battle of experts. Yeah, but okay. We're already there. It's boiled down to a battle of experts. I'll give you that. But in this battle of experts, 2 of those experts have done some shady fucking shit. 2 of those experts have their own companies to promote. 2 of those experts, in my opinion, saw an opportunity to promote their companies in an open trial, a murder trial that is in a high-profile state. That's what I believe. I believe that they saw that trial and they were probably pitched that this trial would be a nice little advertisement for each of their own companies that they now have. The court should deny the Commonwealth's request to exclude Richard Green's testimony concerning the 2:27 a.m. artifact. The motion of the Commonwealth is deficient on its face. I love that shit. The Commonwealth's motion to exclude certain expert testimony of Richard Green is deficient on its face in the 2 aspects of Daubert-Lanigan applicable to this motion. The Commonwealth claims that Mr. Green is not qualified and that his methodology is unreliable, but provides no explanation as to why. In fact, the Commonwealth doesn't even describe the methodology of Mr. Green, which it asserts is unreliable and seeks to exclude. The Commonwealth's motion is not only bereft with respect to the two apt prongs of the Daubert-Lanigan inquiry, but also, well, which is qualifications and reliability of methodology, but also with respect to other aspects of its analysis. Nowhere in the motion does the Commonwealth discuss the general acceptance percept of the Commonwealth versus Davis or the 5 non-exclusive factors of Daubert. What little the Commonwealth does say about the law is rote and does not address the question at issue here. The Commonwealth also fails to mention Commonwealth versus Rentala instructs that the crucial inquiry for Daubert-Lanigan proposes is whether the proffered expert is qualified. Mr. Green overwhelmingly satisfies the Daubert-Lanigan standard. Okay, so now I'm understanding a little bit, at least, why the Daubert-Lanigan thing is referenced so much is because, which I didn't read, which is probably why I was lost to this. That's what they're using. That's what the Commonwealth is trying to use to exclude Mr. Green as an expert, as a qualified expert. They're trying to cite this Daubert versus Lanigan as reason as to why he's not qualified. To cite as to why he's not qualified. But the problem is that he's clearly very qualified, and we're going to go over why he's qualified. Get comfortable, folks. We're going to be here a fucking minute. So, and the motion of the Commonwealth is not supported by any affidavit. An affidavit detailing all facts relied upon in support of the motion and signed by a person with personal knowledge of the factual basis of the motion shall be attached to all pre-trial motions. The Commonwealth additionally misses the point of a Daubert-Lanigan inquiry. It argues, for example, that Mr. Green's opinions as to the artifact containing the 2:27 a.m. timestamp lack any evidentiary support, cannot be made in good faith, constitute baseless claims. So the Commonwealth is trying to say that Jennifer McCabe conducting a house-long to die in cold search at 2:27 a.m. on January 29, 2022, just hours before Boston police officer John O'Keefe is found dying in the snow at 6 a.m., that this is baseless. That it's baseless. But it's not baseless because the defense is expert. I mean, here's the thing is, what do? That shit shows up on a Celebrite report. You follow up on it. You do some investigating. You hire an expert. And so this expert, who they hire, applies 5 different tools and draws the same conclusion that the house long to die in cold 2:27 a.m. search did happen and shows up as deleted. And they're trying to say that it's baseless and that it's been debunked. These claims, in addition to being false, and that's their nice way of saying fucking lies, have no relevance to the methodology inquiry. They relate only to cross-examination and jury determinations. And Mary B., member for 6 months, thank you so much. I just figured out I can do this. Hi, Will. Right on. I'm glad you can. Thank you so much. Even if the motion of the Commonwealth was not deficient on its face, Mr. Green easily meets the requirements of the Daubert-Lanigan. Broadly, the Daubert-Lanigan inquiry involves evaluation of both the qualifications and methodology of the proffered expert. However, the critical issue is determining whether a witness is qualified to give an expert opinion, is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. Thank you so much, Karen Reed's defense, for explaining to me exactly what the Daubert-Lanigan thing is. It is referenced by the Commonwealth to, and it is applied by the Commonwealth to try to discredit the expertise and qualifications of the defense's expert. That makes perfect sense to me now. In addition, under Daubert-Lanigan, the judge acting as a gatekeeper is responsible for making a preliminary assessment whether the theory or methodology underlying the proposed testimony is sufficiently reliable to reach the trier of fact. In making that assessment, the court may consider whether the scientific theory or process has been generally accepted in the relevant scientific community. 2, has been or can be subjected to testing. 3, has been subjected to peer review and publications. 4, has an unacceptably high known or potential rate of error. And 5, is governed by recognized standards. When applying the standard, judges must be careful not to invade the province of the jury. Now, remember, those are the 5 things that came up when it came to Dr. Marie Russell. Critically, it is the qualifications and methodology of the expert, not their conclusions, which the judge is tasked with evaluating. Differences of opinion present issues of credibility, which are properly reserved for the jury. Once the expert's qualifications were established, the issues of credibility. Okay. According to expert witness testimony, should not be deemed unreliable simply because there's a disagreement of opinion or in the level of confidence among the experts. Now, I'm going to skip a lot of this because I think we're getting the point. Because I have to try to manage time here as well. Yeah. Let me see something else here. I'm just double checking to see if there were any footnotes. But I don't see any. But the point of this is basically, I mean, I don't need to go over the entire argument of Karen Reed's defense team as to why they're opposing this motion. They're trying to say that he's not qualified, but how can he not be qualified if he applied the same tools? You can't say that he's not qualified simply because he drew a different conclusion than the Commonwealth experts that applied the same just because they have a different result, but applied the same methodology. So how can he not be qualified? How can Richard Green not be qualified if he applied the same methodology as the prosecution's experts? That's basically their point here. Now, I also have the affidavit of Richard Green here, which I'm going to read. And that's where the good stuff is, folks. But I thought that was really interesting because you could see that the defense's gloves are off. They're done. They're like, okay, Judge, you need to start fucking doing something about this. Not, oh, Your Honor, with all due respect and her honors, with her honors, grace in mind. They don't say that shit, but, without having to kiss Bev's ass anymore, they're like, dude, we're sick of this shit. Like, you can't deny this guy from being an expert. How many times are we going to go through this? This is draining Karen Reed. This is bleeding Karen Reed. This is bleeding our client. This is a violation of her rights. Can't challenge every single time defense experts that you, Judge Bev, have already approved in the last trial. We shouldn't even be at this trial, but we are. So I'm of the opinion that now the defense is just thinking about things being on record. They're thinking about appellate courts. Yeah. They're not counting on Judge Bev to be fair anymore. They're just not. All right. Affidavit of Richard Green is in support of defendant's opposition to Commonwealth's motion to exclude certain testimony of defense witness Richard Green. Richard Green under oath. Richard Green under oath, do depose and state as follows. The following facts and information are based on my own personal knowledge, and I could testify competently about them if called upon as an expert witness to do so. I declare that the following is true and correct to the best of my knowledge, and I have no personal interest in the outcome of this case. I am the owner and president of United States Forensics, a digital investigations and data forensics company that provides services to clients nationwide. A copy of blah, 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 blah. I have more than 25 years experience as a computer forensics technician and 18 years of experience conducting electronic data analysis and analyses and investigations, including analyzing computer data, cell phone data, cloud data, digital camera and DVR data, metadata media, and audio and video analysis and enhancement technology. I have conducted thousands of investigations involving computer and cell phone forensics, data recovery, computer networking and maintenance, and audio and video enhancement. My services have been retained by numerous attorneys across the country in both civil and criminal cases, offices of the public defender, and law enforcement agencies. So this guy has not only testified for defense teams, but he's testified for prosecutors as well, and law enforcement. Helped with investigations. I have been qualified as an expert in digital forensics, and if they tried to discredit him, think about that right there. How many times has this guy testified and his expert testimony put away a guilty party? Does this give that guilty party grounds to file an appeal for a retrial? If this expert is discredited on such a high profile level, can that happen? Is my question. I don't know if that can happen, but it's my fear. I will say that. See, these are the possible costs of a miscarriage of justice being perpetrated by a justice system. These are those kinds of costs. And these are the things that we need to understand. It's crazy. And all just to do what? To convict somebody that they don't have any evidence to convict with. To get a win. These are not people acting in the interest of justice. Because if they were acting in the interest of justice, they would be considering the things that I'm talking about now. They would be considering justice being miscarried in so many other cases based on what could happen as a ripple effect of what happens in this case. That's the danger. I have been qualified as an expert in digital forensics in numerous state and federal courts throughout the nation, including California, Florida, Michigan, Kentucky, North Carolina, Ohio, and Massachusetts. I obtained my associate's degree in digital forensics and computer investigations from St. Petersburg College. I am a certified computer examiner with the International Association of Computer Forensic Examiners, which is a globally recognized certification in the field of computer forensics and requires continuing education and recertification every 3 years. I also hold the following certifications: a computer-related crimes investigator certification from St. Petersburg College, a cybersecurity certification from St. Petersburg College, and a computer forensics first responder certification. Interesting. I'm also personally licensed to operate a private investigation agency in both Florida and Michigan, which is a requirement to operate a digital forensics company in both states. That's interesting. I'm presently a member of the following professional associations in the field of digital forensics: International Society of Computer Forensic Examiners, the International Association of Computer Investigative Specialists, National Association of Criminal Defense Lawyers. Wow. I was the keynote speaker on electronic data forensics at the 2008 Midwinter Conference hosted by National Association of Legal Investigators. Jesus. This guy's amazing, dude. Throughout my career, I have kept current with developments in electronic data analysis, including computer forensics and investigation training from St. Petersburg College and first responders training from Institute of Forensic Imaging. I participate in computer forensics listservs, personally research the newest developments in digital and computer forensics, and attend weekly training seminars in digital forensics. Weekly seminars. This guy goes to a seminar every week involving digital forensics. A partial list of training events I have attended over the course of the last several years alone include, but are not limited to, training by Belkasoft, training by Celebrite. Okay, so Android forensics with Belkasoft, unveiling Celebrite in CITS. I don't know what that means. Hexordia mobile data structures, understanding multiple user accounts in Android, training in forensics in the cloud, mobile forensics challenges in workplace investigation, simplifying the digital investigation of the Apple devices, collecting and analyzing mobile evidence, data uncovered, revealing truths in e-discovery, and vehicle system forensics. This is a partial list of the events. So right there, let's talk about what seems to be, with my uneducated ass, what seems to me to be applicable training to the issue at hand. I'm going to go ahead and say unveiling Celebrite. In CITS, I don't know what in CITS means, but I'm going to guess because it's training and using understanding Celebrite. Forensics in the cloud, that would be applicable. Mobile forensics challenges in the workplace investigation, that would be applicable. Simplifying the digital investigation of Apple devices, that would absolutely be applicable. All of these are probably applicable, which is why they're listing them, but I'm going to go over the ones that stand out to me anyway. Collecting and analyzing mobile evidence, data uncovered, revealing truths in e-discovery, vehicle system forensics. Look, more. There's more. It just goes on. Look at this shit, dude. I don't even want to read them all. Look at this. Fuck all that. I'm not even reading all that. That's crazy. Look at that shit. See me scrolling, people? Look. It starts right here. This is the top of that list right here. And it goes on and on and on until it gets to right here. That's how much training, in part, partially. That's a partial list of the training that this man has had that apply to the issue at hand. USF was initially provided with the Celebrite UFED report prepared by Trooper Nicholas Guarino with the Massachusetts State Police. Okay, so this was prepared by Nicholas Guarino. Nicholas Guarino is the one who handed over the data to Richard Green. Guarino handed him that data. And it was labeled as full file system extraction of an iPhone 11, meaning Jen McCabe's iPhone 11. In the initial report prepared by Trooper Guarino, the 2:27 a.m. search for House Long to Die in Cold did not appear. Recognizing that this report was not the best evidence, I personally requested the image file for the phone in question, which I had reason to believe was produced using the Key Green product based on the naming convention contained within the Celebrite report. I subsequently received a USB drive containing a forensic image of the iPhone 11, described as J. McCabe, belonging to Jennifer McCabe, which was forensically imaged by the Massachusetts State Police using a tool known as Gray Key. The USB drive containing the forensic image was sent to USF by Assistant District Attorney ADA Lally with the Norfolk County District Attorney's Office by way of Trooper Guarino with the Massachusetts State Police. Fascinating. Upon receipt, the USB containing the image of Jennifer McCabe's cell phone was assigned an internal evidence number with USF evidence number 22, blah, 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 blah. Notably, the USB drive containing the forensic image of Jennifer McCabe's cell phone failed to include the associated documentation containing the hash value, which is a well-known mechanism used to validate the data and ensure that it is not changed or otherwise been manipulated. After personally insisting that the Massachusetts State Police provide the hash value associated with this data, USF was eventually provided with a PDF containing the purported hash value, and the value listed within the PDF matched the Gray Key image file of the cell phone in question. Now, if you guys remember, Olivia Nile she wrote a long tweet about this, a very confusing one, but basically pointed this out about the hash value. She did this whole long analysis on hash value. And now they're saying that the defense brought this to the Commonwealth's attention, and then they were provided this hash value, this data containing the hash value. After obtaining the full file system extraction of the data contained by Jennifer McCabe's iPhone 11, the data images were processed and reviewed with Celebrite Physical Analyzer, blah, 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 and Axiom Forensics. It's my professional experience. In my professional experience, an analysis of a device's internet search history often gives valuable clues as to the user's intent or knowledge surrounding an incident. Now, remember, he's qualified to say this. Now, a lot of times, you guys got to remember, a lot of times, an expert is going to go, what the fuck? Like, say, for instance, if Dr. Russell would have said, it's my opinion, like in her report, if she were to say something like, it's my opinion that there's something wrong with the DNA analysis of John O'Keefe's, like, it's my opinion that that a swab was tested and not an actual piece of John O'Keefe's clothing. Right? Then Brennan could argue, well, she's not an expert in DNA. Why the fuck is she putting her opinion on DNA collection and analysis? Why is she doing that? She's not qualified. She's not an expert in that. But the difference here is this dude can talk about Jennifer McCabe's intent or knowledge surrounding the incident of the Google search. And the reason why he's qualified in doing so is because he's required to apply for, get certified, and maintain a private detective certification, a license for being a private detective. So therefore, he is licensed and qualified to make this assessment, to look at Jennifer McCabe's searches and go, oh, she was doing that shit dirty as fuck. That's a dirty delete if I ever fucking saw one. If Hank Brennan tries to say, who is this guy and why is he trying to say that his expert, what is his expert opinion? Well, his expert opinion is that he's a private detective. He's perfectly qualified to make that assessment and say that there was something absolutely fucking nefarious going on with that search. But we haven't gotten there yet. All he's doing is saying, in my opinion, well, based on my experience, I can analyze. I can tell if someone's search is likely nefarious. If there was a malicious or nefarious intent behind the actions of the phone user. Because he's qualified to do that. And it's required. It's required to be an expert in his department, to be licensed and to be qualified as an expert. He has to also carry a private detective's license as well. So that means he's licensed to investigate crimes. I conducted a review of the search history information obtained from Jennifer McCabe's iPhone 11 and observed the following significant artifact. You guys just saw my dyslexia go off right there. And observed the following significant artifact from the morning in question as reported by Celebrite Physical Analyzer, blah, 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 and Axiom Forensics, blah, 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 blah. Which were the most recent versions of the respective tools at the time I conducted my initial analysis. Okay, so at the time when Richard Green conducted his iPhone analysis, Celebrite was the latest update. And that's the argument that Plevin's always trying to throw out there, and these trolls are always trying to throw out there. Oh, he analyzed the old version. They updated a new version. No. Ian Whiffen updated Celebrite. Ian Whiffen, a witness for the Commonwealth of Massachusetts, updated Celebrite, who happens to be an employee of Celebrite, updated Celebrite. That's the difference. That right there shuts down that argument coming from Plevin right there. Or any other fucking idiot like Jennifer Twattendorfer. Oh, it's the old version. Okay. But you're failing to explain why we have a new version. Why do we have a new version? Why is there a new version? And the new version seems to the only difference between the new version and the old version seems to be the 227 searches that show up anymore. That seems to be the only difference. So this is very fascinating. Right. Yeah. She's an expert. So he ran these diagnostics. Search term: how long to die in cold. Last view date and time: 2:27 a.m. And there's the URL for it right there. Safari is the source, and the state of it deleted, and it is a WAL file. In Celebrite physical this is going to explain Celebrite processing. In Celebrite physical analyzer version, blah blah blah, how long to die in cold. Search not only showed up at the web history, but Celebrite further refined the results and included it in the searched items artifact section. It was marked as deleted record. It was marked as a deleted record with an adjusted last viewed timestamp of January 29th, 2022 at 2:27 a.m. and 40 seconds. Noting the inconsistencies in Celebrite's reporting between the UFED report generated by blah, blah, blah and Celebrite's physical analyzer, I contacted Celebrite's technical support to inquire if they could provide additional information about the artifact. Celebrite's technical support staff indicated that they believed the artifact was reliable and that no issues had been brought to their attention. That's interesting. On April 22nd, 2024, the Commonwealth's expert Ian Whiffen emailed me stating, okay, stating the last visited time shown in Pennsylvania will be getting removed from the artifact. PA. I'm saying Pennsylvania, but I'm guessing physical analyzer. Maybe is that what he meant? The last visited time shown as PA will be getting removed from the artifact in the next available version of physical analyzer. You see, I'm laughing at myself because I said Pennsylvania, right? After the state of trial in this case in late May of 2024, the Celebrite released in its physical analyzer. I still don't know what that word means, which removed the 2:27 a.m. timestamp from its processing of the artifact. Wait, what? Yeah. So he's saying that the update itself is what removed the artifact, the 2:27 a.m. search. From its processing of the artifacts. Shortly after the trial on July 22nd, 2024, Celebrite released its Celebrite physical analyzer standard, blah, 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 which also removed the 2:27 a.m. timestamp from its processing of the artifact. Notably, Celebrite is a company that markets itself as providing digital intelligence solutions for law enforcement and is used by over 6,900 public safety agencies in over 100 countries worldwide. Although I am aware that Celebrite recently changed its analyzer program so that it can no longer reports on the timestamp of this particular artifact, I have not misinterpreted the data. Okay, so why the fuck is Ian Whiffen emailing Richard Green? I think Turtle Boy talked about this last night. Why the fuck is Ian Whiffen emailing Richard Green? One might say it's a courtesy amongst colleagues, right? One might say that. But I'd like to know how often that happens. I'd like to know if that's considered a conflict of interest in some way, shape, or form, or some sort of ethical violation where the witness for the Commonwealth what's the word I'm looking for? Where the witness for the Commonwealth will liaise, I guess is the word, with the witness for the defense. Compare notes. Talk to each other at all. Clever, no. Come on, buddy. So that's really weird that they're even talking to each other. I don't understand that. I don't understand why. I mean, wouldn't that be some sort of ethical problem because there's influence coming from one side towards the other side? Isn't it unethical for the expert hired by the Commonwealth to contact directly the expert hired by the defense? It's got to be weird. There's got to be something wrong with that. I mean, maybe there's not, and I don't know about it. I don't know. Yeah, he's saying, regardless of those updates that have taken place, I have not misinterpreted this data. He's not even saying I could have, maybe, I don't know. It's possible based on this, and that happened, but I don't think it did. In my expert opinion, I do not believe that's the case. That's not what he's saying here. What he's saying is, I did not misinterpret that data. Meaning, I know what the fuck I'm doing. I know what the fuck I did, and I know what the fuck I got to say now. I didn't stutter. Axiom processing. Axiom is an application product offered by Magnet Forensics, which is a competitor of Cellebrite. Best practices in digital forensics require forensic examiners to view data and artifacts with more than one tool. Therefore, I also processed the image of Jennifer McCabe's iPhone using Axiom version 6.11. Axiom version 6.11 reports the 2:27 a.m. search artifact for Haslong to die in cold with a last viewed time of 2:27 and 40 seconds a.m. in the Safari suspended state tab section. Shortly thereafter, I contacted Magnet Forensics technical support to see if additional information could be provided regarding this artifact. Okay, now, before I continue this, I still have another thought about, like, what's going to happen. I wonder, because I didn't see anything stating that Richard Green responded to Ian Whiffin's email. I didn't see anything stating that coming from Richard Green. This is this sworn affidavit. So I'm curious about that. And I wonder if the defense is going to ask Ian Whiffin on the stand if that's considered normal practice, since he's an experienced expert testifying in trials. If that's normal practice, I wonder if the defense is going to ask him that and point out how fucking unethical that shit, or at least shady looking, that is. I was advised by technical support that the 2:27 a.m. timestamp indicates that the search would have occurred sometime at or before the 2:27:40 second mark. Time indicated. Since my initial analysis, USF has upgraded to the more advanced Axiom Cyber Physical Analyzer, which was released on December 17th, 2024. This version of Axiom continues to report the above artifact with an even more precise last view date time of 1/29/2022 at 2:27 a.m. in the Safari suspended state tab marked as deleted. Moreover, Axiom's user manual describes this artifact as follows: Safari suspended state tabs, last interaction, date, time, blah, 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 the state and time of the current tab's state when it was last interacted with on the local device. The date and time will reflect when the user has last interacted with this tab in Safari, or if the tab auto refreshed on the local device only. In order to validate this timestamp, I looked at the numerous examples of web sessions on Jennifer McCabe's device, including URLs containing Raining Men, Canton, Massachusetts.org, hockamocksports.com, and easternbank.com. In all of these instances, the browser state entry appears at the end of the session. This is consistent with how Magnet describes the artifact. So, according to Magnet, according to Axiom, not only are they saying that not only is that tool showing Richard Green that the 2:27 a.m. how long did die in search, that search happened, how long to die in the cold search happened at 2:27 a.m. and was marked as deleted. So she tried to delete it. Not only does the Axiom data show this, but it also shows that she tried to Google these other things to cover up that Google search after she deleted that, to say, oh, well, I tried to delete something else, which also indicates to me that it's quite possible that Jen McCabe is so fucking manipulative that her abilities in manipulation run so deep in this case. Her influence runs so deep in this case that she went to the Commonwealth and said, hey, I freaked out and I searched 2:27 a.m., but I deleted it, and I was hoping that I could search these other things and in the same minute, because it doesn't go by second, does it? I don't know that. Or let's not forget what her husband does for a living. Maybe Matt McCabe's doofy ass said, okay, well, the best chance you've got right now is to delete that search because that could be traced. Delete that search right now and start searching other things. And then we'll just say that the system got confused. Now, I'm just theorizing here. I don't know. But if she deleted that shit immediately, if she deleted that search as soon as she did it and then started searching other shit, and then confidently sat on the stand saying this was my process, that tells me that that was her plan all along. That she pictured herself sitting on a stand in open trial, having to defend herself against that search. Now, maybe not Karen Reed's trial, but most likely her trial when she's charged. Because that deletion and those immediate searches that took place after were clearly an act of self-preservation. So I'm guessing that she was probably picturing herself sitting on the stand, testifying on her own behalf, because narcissistic assholes always do this. They don't always testify because they always have attorneys that tell them not to, but they always want to testify. They always want to. Because every single narcissistic piece of shit who's guilty of murder, who is regardless of all of the evidence against them, they want to drag things out in a trial, knowing that their case is high profile, or hoping that their case is going to be high profile. And that's their show. They have an audience. They have a jury, which acts as their audience, their final audience, their last chance to perform. That will determine, this is the performance of their lifetime, by the way. And it will determine whether or not they go to prison for the rest of their lives. Exactly like Sarah Boone. Exactly like Letitia Stout. Now, Letitia Stout eventually listened to her attorney and decided not to testify. She wanted to. Because you need to hear my truth. You all need to hear my truth. I'm the victim. That's what these assholes always do. And so I guarantee you that Jennifer McCabe was picturing herself in her mind, testifying at her own trial, sharing with the jury her own truth. My truth. It's my truth. And now that I have you all here listening, it's time you hear it. That's that bullshit. That's that bullshit. Jodi Arias as well is a fantastic example of that, Trisha. That's what these assholes always do. Even if they don't testify, if they don't testify on their own behalf, it's usually because they have lawyers going, you don't want to do that. Too risky. You don't want to do that. But I'm so sure that if they hear my truth, they'll know, well, your truth is a fucking lie, is the problem. Like, you're going to look like a fool. And even innocent defendants, it's better to not take a stand, because again, it's a risk. It's a risk in how the jury is going to interpret you. You don't want to take that chance. You want to eliminate that possibility that the jury is going to hear you talk and fucking hate you if they already liked you. Nelson Calderon. Thank you so much. Jen will start talking. She is not going to jail by herself, believe it or not. Yeah, no, I agree with that. Oh, for sure. If they turn out to have enough, and that's going to be difficult. If they turn out to have enough to charge Jen McCabe, she'll fight it. Because even if you have enough to charge Jen McCabe, you don't have the actual murderer, unless you could charge her with it. But it all depends on how strong of a case that is. Is there a prosecutor who believes that if they charge Jen McCabe, and let's just go based on what we know, because I'm sure there's other shit the feds have that we don't know. Tons of shit. But let's just go with what we know publicly, right? Will a prosecutor likely think that with what we know, that would be enough to convict Jen McCabe without being able to tell a jury, this is the person who actually killed John O'Keefe? And I don't mean Jen McCabe, without actually being able to point out who actually killed John O'Keefe. Can you charge her with an accessory to being an accessory to murder? Would that hold any water? Can you charge Jen McCabe with accessory to murder when you don't have the actual murderer in custody or charged? I don't think you can. Personally, I don't think you can. But the question is, does a prosecutor think that if they present their case to a jury, will it be enough to convince that jury beyond a reasonable doubt? And it all lies on that 2:27 a.m. search. All of it lies on that. But here's the problem with that. Is that alone, the Commonwealth's argument alone, would be enough, in my opinion, to create doubt. If she denies ever making that search at that time, and they have a couple of experts sitting on the stand throwing around a bunch of technical mumbo jumbo bullshit, confusing the jury, will that be enough to create reasonable doubt that she even conducted the search? Probably. Will the 911 call be enough to contribute to taking away that doubt? Would the footage of her running inside the house when she could have done that at any given time be enough to eliminate the doubt from the 227 search? Will all of the other things that we've seen her do that is absolutely nefarious, the lies that she was caught on during the first trial, will that be enough to eliminate the doubt in a jury if Jen McCabe is on trial? Would that be enough to eliminate doubt in a jury that she's guilty of being an accessory to this murder? Now, I'm totally convinced. I am absolutely, totally convinced that Jen McCabe not only conducted, I've been convinced that she conducted that 2:27 a.m. Google search. But I'm also convinced that Jen McCabe is guilty of having a hand in John O'Keefe's murder, because I believe that Jen McCabe had the power to save his life. And I believe that that Google search proves that Jen McCabe had every intention of letting John die out there in the snow. That's got to be murder. That means she knew what happened to him. She knew he was out there in the snow, and she was counting on the cold to kill him. Ultimately, that's got to be a murder charge. So when I say these words, understand that I believe them with all of my heart. Jen McCabe is a fucking cop killer. I absolutely 100% believe that. Based on all of the evidence that I am aware of, Jen McCabe is absolutely a fucking cop killer. In order to confirm the accuracy of this search event as reported in Celebrite Physical Analyzer, blah, 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 and consistently throughout multiple versions of Axiom, I then independently performed a low-level analysis of the artifact, which was located in the browser state. Write-ahead files are temporary in nature and show the location where data is written before commitments to the main database are made. The particulars of this artifact are as follows. Location, private, var, mobile, library, Safari, okay. Database record, raw time, blah, 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 blah. I don't understand any of that. And here's a footnote. I would also note that Trooper Nicholas Guarino's report labeled NFK CAN MFP CNFB PDF specifically mentions that he also used the Axiom product to process the forensic image of Jennifer McCabe's iPhone. Okay, this is where it gets interesting. Because remember, right here, he says that consistently throughout multiple versions of Axiom, in order to confirm the accuracy of this search event, in order to confirm the accuracy of the House Long to Die in Cold search at 2:27 a.m., as reported in Celebrite Physical Analyzer, and consistently through multiple versions of Axiom, he then independently performed a low-level analysis of the artifact. Okay? A low-level analysis. But after he performed searches and analyses using multiple versions of Axiom, not just one version, multiple versions of Axiom, and concluded the same thing, that Jennifer McCabe searched House Long to Die in Cold at 2:27 a.m. on January 29th, 2022, and tried to delete it. That's a fact. That happened. But it's interesting here. Multiple versions of Axiom is just part of what brought Richard Green to this conclusion. Now, This footnote says, I would also note that Trooper Nicholas Guarino's report labeled blah, 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 specifically mentions that he also used the Axiom product to process the forensic image of Jennifer McCabe's iPhone. I personally tested the earlier version of Axiom, the same version that Nicholas Guarino supposedly used, which would have been used in February 2022, and determined that the 2:27 a.m. version of the Hotslog to Die in Cold search was reported by Axiom as having a last viewed time of 2:27 a.m. Axiom has a similar feature to Celebrite with their creation of a portable cause. This exculpatory information was never turned over to the defense. Okay, that's very important. So Guarino covered up evidence. Guarino hid evidence. Trooper Nicholas Guarino is a piece of mierda. Because Trooper Nicholas Guarino used the same version of Axiom and came up with no 2:27 a.m. search. Not deleted. Amazing. Wonder why those were the first words that came out of his mouth when he sat on the stand. I wonder why. I personally tested the earlier version of Axiom, which would have been used in February 2022, and determined that the 227 was Axiom has a similar feature to Celebrite with their creation of a portable case. This exculpatory information was never turned over to the defense. I used 3 additional forensic tools to conduct a low-level analysis of the artifact in question, including Belkasoft X, Sanderson Forensic Browser, and ArtX2, a research-based program by the Commonwealth's expert Ian Whiffen, which only has approximately 600 users worldwide. Oh my God. All 3 of these programs show data consistent. I love the techie fucking pissing contest that was just there right there. I love that I love that in this dude's sworn affidavit, he's going, yeah, this Ian Whiffen dude, he ain't shit. That's Richard Green's way of going, yeah, Ian Whiffen ain't shit. What? That bitch, he developed a fucking program, but it's only got 600 fucking users. Fuck that guy. He ain't shit. When he takes half of my seminars, he can talk to me. Fuck that guy. All 3 of these programs show data consistent with the search for Hotslog to Die in Cold, with the last viewed time field of 2:27 a.m. being found on record. 4028. So even this dude's ain't shit fucking this dude's own program, the Commonwealth's witnesses, the Commonwealth's experts' own program, Ian Whiffen's own program, was used and applied by Richard Green, the defense's expert, and he came up with the same result. So think about that for a second. In a nutshell, Ian Whiffen's own software from his own company, not Celebrite, his own independent company that he started after he left Celebrite. His own software was applied by the defense's expert and showed that Jen McCabe Googled Hotslog to Die in Cold at 2:27 a.m. That's massive, dude. Think about that for a second. Think about that for a second. Imagine how that's going to look in court. When defense cross-examines Ian Withen and says, were you aware you developed this software? How reliable do you think this software is? Do you consider your software to be reliable? How reliable do you consider your software to be on a scale of 1 to 10? And 11? Okay, cool. So how do you explain that your software was applied by our expert, Richard Green, and it came up with the same conclusion as all of the other pieces of software, all of the other tools used? Explain that. Because you're sitting up here saying that the 2:27 a.m. search is a mistake. It didn't happen at 2:27 a.m. It happened at 6:34 a.m. Okay. You're up here testifying this, right? Okay. So explain how your software says that she did. Your software that you developed, Mr. Ian Withen, explain how that's coming up with a different conclusion than you're testifying to today. Easy. Mic drop. Done. Done. How the fuck is that guy going to explain that his own software contradicts his testimony? How's he going to explain that? It is my opinion, based on a reasonable degree of scientific certainty, that the user of Jennifer McCabe's cell phone searched "Haas long to die in cold" at or before 2:27 a.m. I have also consistently reported the existence of 2 additional search artifacts found on the forensic image of Jennifer McCabe's iPhone, which suggests that the user of Jennifer McCabe's iPhone 11 made 2 additional similar searches later that morning on January 29, 2022. 6:23, how long die in cucked? And how long to die in cold at 6:24? That's interesting. Okay, we're going to have to take a little intermission, guys, for just a second, okay? But I'll keep you guys as entertained as I possibly can in the meantime.
Deactivate. Get it together.
All right, I'm sorry about that, folks. Appreciate you. Clubber really had to go out, so had to be done. Oh, wait 1 second here. All right. Sorry about that, guys. Appreciate you guys sticking around. Opinion number 2. It is my opinion, based on a reasonable degree of scientific certainty, that the 2:27 a.m. search artifact for How Long to Die in Cold was deleted by either deliberate user interaction or manual post-imaging manipulation of the data by some unknown individual. So he's not flat out accusing Jennifer McCabe of deleting the search. He's saying whoever the fuck had her phone at 2:27 a.m. or before, or whoever had her phone at 2:27 a.m. deleted the search. Because 2:27 is when the deletion takes place. So that's why they're saying on or before 2:27 a.m. is when the search took place. So even if it happened before, if it happened anytime before 2:27 a.m., it makes her look even that much more guilty. So Jennifer McCabe absolutely searched that shit. This is well, no, that's not. Yeah, we're not going to do that poll because Guadagnino couldn't have deleted this at 2:27 a.m. because he wasn't made privy to the situation yet. I think if anybody besides Jen McCabe did that, it was Matt McCabe, considering what he does for a living, considering he's a tech guy. But no, I don't believe that. I mean, it couldn't have happened. Guadagnino did not delete the search. I think he deleted it from or deleted it from his report. I think he saw it and didn't say shit. Right, exactly. The search was deleted by at 2:27 a.m. The data was deleted later. And the data was deleted most likely by Trooper Guadagnino. Possibly by Matt McCabe, but most likely by Trooper Guadagnino. Oh, yeah, it could have been earlier. It is inconsistent that the 129, 220, the January 29, 227 a.m. search artifact for How's Long to Die in Cold found in record 4028 is in a deleted state. It is uncontested, that the search artifact is in a deleted state. Databases contain tables with numerous fields, and in some cases, there are programmed field entry to indicate whether a record is live or deleted. With regard to the browser state, DB, which is the database at issue here, which is no such field to indicate whether a particular record is live or deleted. However, based on the characteristics of the data contained within the associated write-ahead log wall file, the forensic tools indicate that the 2:27 a.m. How's Long to Die in search found in record 4028 is in a deleted state. Which proves, by the way, that Jen McCabe lied on the stand because she emphatically denied deleting anything. She sat on the stand and denied deleting any of the searches. She said, I didn't delete anything. I didn't delete any phone calls. I didn't delete any text. I didn't delete any searches. I didn't delete anything. There are several reasons why data may appear to be in a deleted state, which include a deliberate user interaction, an automated function of the operating system, a system application or operating system update, a malfunction of the operating system or hardware, or manual post-imaging manipulation of the data itself. I address each of these potential scenarios in turn. Wow. Manual post imaging. So this is all process of elimination put out in a sworn affidavit, in writing, in a sworn affidavit, not just in writing, but in a sworn affidavit. This is his process of elimination, documented and listed as to how he emphatically and undeniably reached the undeniable conclusion that this search happened and was deleted at 2:27 a.m. So one process was the manual post-imaging manipulation of the data. Typically, data collections have an associated hash value, which is unique to that set of data. The hash value is created using an algorithm and is a well-known mechanism used to validate the data and ensure that it is not changed or otherwise been manipulated in this case. The USF was originally supplied with a forensic image of Jennifer McCabe's cell phone, which was created with a tool known as Gray Key from Assistant District Attorney Adam Lally with the Norfolk County District Attorney's Office by way of Trooper Guadino with the Massachusetts State Police. However, and remarkably, the associated documentation continuing the hashtag value needed to validate the image was not provided with the initial USB drive containing the forensic image of Jennifer McCabe's cell phone. This was incredibly unusual. In all of my years working as a forensic examiner, this is the first time I have ever received a forensic image of a phone without the corresponding hash value, which means that Trooper Guadino had to have fucking deleted the hash value. He had to have taken the hash value and removed it from the data before it was turned over to the defense. Now, if you remember, Olivia did a long tweet about this a while back. I brought this up earlier. Olivia did a long tweet explaining this, that this is incredibly nefarious. Why was there no hash value to the data that was turned into the defense? Why was that hash value deleted? And Olivia explained that it had to have been removed manually by Trooper Guadino. That is, by definition, a cover-up. that is by definition concealing or excluding or hiding exculpatory evidence from the defense. That is, by definition, corruption. Make no mistake about that. Like, it's just so funny to me, dude. Like, she posted this months ago. She caught this months ago and posted about it. She provided video footage of Guarino testifying that there was no hash value. But the hash value, Olivia pointed out that the hash value had to have been physically removed before it was turned over. That was intentional. So when I think about that, like sitting here and reveling in this and looking back on, wow, Olivia pointed this out months ago, through her own independent investigating and looking into, she did this. Right? And then it brings me to my pettiness, brings me to petty glare, right? Where I'm like, how fucking ridiculous is Plevin to think that he can debate someone with the intelligence of Olivia? The inclination to be so thorough that Olivia has. The fact that Plevin has the audacity to try to debate this person and try to debunk this person is fucking comedy to me. Plevin, the same fucking guy that sat on court TV and speculated that Higgins was ordering a pizza at 2 a.m. when he was outside of the Canton Police Department doing what he testified he wasn't doing. After personally insisting that the Massachusetts State Police provide the hash value associated with this data, USF was eventually provided with a PDF containing the purported hash value, and the value listed within the PDF matched the gray key image file of the cell phone in question. However, as Mr. Whiffen acknowledges in his report, the Celebrite program cannot validate the data. The value is unsigned. In other words, the gray key image of Jennifer McCabe's cell phone could have been manipulated, then rehashed after the manipulation, and still show the same resulting hash value included in the PDF file. That's interesting. Okay. I'm going to read that one more time because I had to read that silently to understand it. In other words, the gray key image of Jennifer McCabe's cell phone could have been manipulated. Could have been. He doesn't outright accuse Guarino of manipulating it. Then rehashed after the manipulation and still show the same resulting hash value included in the PDF file. Typically, forensic examiners are provided with the raw image file and the associated hash value documentation together. After validating the hash value, I would then accept that the data has not been manipulated. Here, however, the hash documentation was not provided with the raw image of the cell phone. Instead, it was withheld from the defense. As a forensic examiner, having received hundreds of imaged phones over the course of my decades-long career, this was unprecedented. That means that he has never seen it. It has never happened. Typically, forensic examiners are provided with the raw image file and the associated hash value documentation together. After validating the hash value, I would then accept that the data has not been manipulated. So the hash value actually indicates, as explained by Olivia a couple months ago, The hash value indicates whether or not the data has been manipulated. That's the purpose of the hash value, or at least why they look for it. After validating the hash value, I would then accept that the data has not been manipulated. Here, however, the hash documentation was not provided with the raw image of the cell phone. Instead, it was withheld from the defense. As a forensic examiner, having received hundreds of phones over the course of my decades-long career, this was unprecedented. So, yeah, he's never seen. That means that it had to have been removed. That means that when you turn over this data, the hash value is included in it. It just is there. Someone had to have taken that data out manually. For that to be turned over, for that data in a USB drive to be turned over to the defense without hash value, that has never happened. And so what he's saying, since that has never happened, he basically he believes that it was removed. He isn't saying that, but he's saying it without saying it. I mean, because what other conclusion would there be? What other conclusion would you draw from that? Dude had to. All right, now let's do this. Sorry, give me 1 second. I'm just searching for something, but I know I'm searching in the right place. So it's just going to take a second for me to get there. But now I'm trying to figure out if this happened before. Here we go. No, that's not it. Because Olivia actually spent a lot of time on Trooper Guadino's testimony and really breaking it down. And I love that, because most of us are just like, this stuff is just too fucking complicated. There's no way I'm going to understand that. Olivia's like, chill. I got this. I got this. I will explain this to you. And it was hard to understand. I remember both me and Melanie Little were definitely scratching our heads over it. And now I'm trying to find that post. And I hate when that happens, because I can never find what I'm actually focused on. Yeah, this is the stuff about the Lexus. Can I search Olivia's post? I don't think I can. Yeah, she posts a lot. It's kind of hard to find here. I know it doesn't go all the way back to fucking like before April. That's crazy. All right, that's July. I'm not going to spend too much time looking for this. I just thought it would be helpful to go over Olivia's analysis of this hashtag or this hash value stuff. But I'm not seeing that anywhere. So I guess we're just not going to do it. Typically, forensic examiners are provided with the raw image file and associated hash value documentation together. After validating the hash value, I would then accept the data. All right, I already read all that. In addition to law enforcement's failure to initially provide the hash documentation associated with the raw image of Jennifer McCabe's cell phone, there were additional anomalies within the process data that are suggestive of manipulation as reported by tools such as Celebrite and Axiom. Those anomalies discussed in further detail below, along with other anomalies in this case, including law enforcement's failure to properly document the chain of custody of items of evidence, inconsistencies in official reports, and testimony regarding the collection of evidence, law enforcement's failure to properly photograph and document the evidence, and the destruction of other crucial electronic data are all suggestive of post-imaging manipulation. Now, again, some of you may be like, I don't know. Why is he qualified to say that? He's qualified to say that because he's a private detective. He's a licensed investigator. So he's perfectly qualified to draw that conclusion based on all of the other shit that we have been bitching and moaning about for months and months and months, for well over a year. Based on all of that shit, that indicates to him that this hash data was manipulated. Okay. Let me see here. Oh, right on. Okay. Oh, so it was Ian Whiffin's testimony. That's why I couldn't find it. I passed it like 5 times. Because I was looking for Guadino's testimony. I thought it was Guadino's testimony. All right. So here, let's stop this for a second. We'll come back to it. So, and thank you so much for that shock and horror. I appreciate you. So here it says, why did Ian Whiffen agree to give expert testimony? Now, this is from July. I think it's from July. September. Why did Ian Whiffen agree to give expert testimony on Jen McCabe's cell phone extraction when the state refused to let him look at or even give him the full original extraction or its verification hash, a thread? Full cell phone extraction, sometimes called forensic images, generate what's called a hash value. And here, I'll share this with you guys. Make sure to follow Olivia on Twitter. Oh, really? We'll do that later, Nick Rocco, if I'm still live. That's awesome. And Marie, member for 2 months. Thank you so much. Did Guadino really say kill me on the stand? He totally did. It was the first thing that came out of his mouth. He totally did, Marie. That is 100% factual. It's the internet's fucking forever. There's no escaping that. So, no, it's real. It's absolutely real. So, full cell phone extraction, sometimes called forensic images, generate what's called a hash value, which serves as a unique digital fingerprint necessary for ensuring the integrity of the data. Any discrepancy between the hash values indicates tampering with or corruption of evidence. alerting forensic examiners to potential issues with the evidence. Hash verification is a fundamental principle and a rather ubiquitous practice in the world of digital forensics, where data violation and verifications are key. In the gold standard across the industry, and has also become so in the courtroom, whereby admissibility of digital evidence is determined by its relevance, authenticity, and reliability. Okay? So that's what it boils down to. The hash value basically determines the credibility of the evidence. In court, the hash value could be used to demonstrate the evidence has not been altered since its collection and is a universal way for experts to authenticate and validate the reliability of data for the trial court. But an extraction that's missing a hash value altogether is a huge red flag. Who removed the hash value and why? It's necessary to the chain of custody, and as Guarino and Tully would be well aware, it is also an element of the data that an expert would require in order to verify and validate it. There's no good reason why someone would remove a hash value, and the extraction can't be characterized as a forensic image as its origin is unknown. I mean, people, this is not, come on, more coincidences? More coincidences? Let's explore that. So the hash value is removed from Jen McCabe's phone data. The hash value is removed from Jen McCabe's phone data, and the original footage, the original DVR data from the Sallyport video, from the Sallyport footage, has been, it's disappeared. It's gone. What was turned over to the defense was manipulated. It was altered. There are timestamps missing. It is inverted. I mean, everything has been manipulated, and all things indicate that they were manually manipulated. And the reason why these things are that this is indicated, the reason why it's an indication, what is an indication that these things were manually manipulated, is because they were manipulated in such a poor manner, such a sloppy manner. You're going to outsmart Richard Green? Okay. This is what this guy fucking does. He's the digital equivalent to fucking Dr. Russell. It's unreal. This was a deliberate step taken to hide something which one could argue shows consciousness of guilt. If the data are true and accurate, why would you bring their integrity into question by removing the hash? However, if the data were altered or tampered with, and let's say, hypothetically speaking, you wanted a digital forensic expert to provide testimony supportive of your Google search theory, in that hypothetical, you'd have to remove the hash value. Otherwise, the expert would immediately detect that the data were altered, as they would not be able to verify the hash against the original.
Now, the hash mechanism that you testified as far as detecting whether or not someone had surreptitiously gone in and deleted things, did you see any evidence of that in your review of the extraction of Mr. McCabe's phone?
I didn't have access to the hash information to see whether any changes had been made. That's something that the original examiner would have had access to.
Okay. That's a big red flag right there. So that's Ian Whiffen testifying in the last Karen Reed trial. And that's Adam Lally asking this question of his own witness. This is his own witness. This is his own expert. And let's listen to what he says right here one more time.
Now, the hash mechanism that you testified as far as detecting whether or not someone had surreptitiously gone in and deleted things, did you see any evidence of that in your review of the extraction of Ms. McCabe's phone?
I didn't have access to the hash information to see whether any changes had been made. That's something that the original examiner would have had access to.
Okay. Now, these are this is the stuff explaining hash value. And what Olivia referenced to come to her opinions. Authenticating, hold on. Hash values. Failing to follow the basic steps of maintaining chain of custody of evidence by creating a verification hash of collected evidence leaves the question of the authenticity of the evidence open. Look at this. This is from Digital Forensics for Legal Professionals. This is a journal, and this is a published opinion by Larry Daniels in 2012. Fucking 2012. The dangers of court testimony without verification. Failing to follow the basic steps of maintaining chain of custody for evidence by creating a verification hash of collected evidence leaves the question of authenticity of the evidence open. The purpose of the hash value is to be able to, at any time, compare a file or an entire hard drive's worth of evidence to prove that the original is identical to the evidence being presented without alteration. So basically, think of a hash value as think of hash value as the think of the hash value as when you open a bottle of milk, right? There's that band around the cap. The hash value is that band around the cap. Once it's broken, once it's gone, then would you buy a bottle of milk, a gallon of milk, or a half gallon of milk? Would you buy that half gallon of milk without that band on the cap? I wouldn't. You know why I wouldn't? Because I don't know if it's been tampered with now. That band ensures to me that I'm buying milk that has not been fucked with, at least by anybody in the store or anybody from the milk factory or anybody beyond the milk factory to my hands. That's what that little band does. So once that band is gone, that hash value, well, then you don't know that it's been fucked with, do you? That ensures that the evidence has not been tampered with or altered. Right. It shouldn't have even been entered into evidence, Microdots. You're absolutely right. It should not have even been allowed in. So I'll just go over the highlighted points here because, again, I'm trying to manage time here. Any discrepancy between the hash values indicates tampering or corruption. Yeah. Alerting forensics analyst to potential issues with the evidence in court, the hash value can be used to demonstrate that the evidence has not been altered since its collection. Digital evidence is vulnerable to tampering, either intentionally or unintentionally. Hash values provide a robust mechanism for detecting any changes to the evidence. Even the smallest alteration to a file will result in a completely different hash value. Forensic tools that generate and compare hash values can quickly detect such changes, ensuring the immutability of the evidence. This feature is particularly useful for identifying unauthorized access or malicious modifications. Now you guys were very satisfied with my milk analogy, but let me give you a more accurate analogy. A more accurate analogy is that digitally, a hash value is the equivalent to an evidence seal over an evidence bag, and it says evidence on it. And if that evidence seal is broken, well, then that evidence has probably been tampered with, hasn't it? So that is the digital. A hash value is the digital equivalent to a evidence sticker seal that is designed to seal that is designed to seal a bag of evidence in order to ensure that that evidence has been preserved properly. That's the purpose behind it. That is the purpose that it serves. That is its function. And it says here, Whiffen even acknowledges the importance and necessity of hash values for verifying data integrity. He brings this up when asked if the data were altered, saying it's potentially possible, but would require a large amount of knowledge and skill to do in a way that can't be detected. Okay, so Whiffen is testifying to this. What we're about to hear Whiffen testify, according to Olivia, what we're about to hear him testify in open court is basically confirming that it takes somebody who knows what they're fucking doing to remove that hash value. That means that it couldn't have just accidentally happened. Some asshole who knows about tech, who knows what hash value is, has to be knowledgeable enough to remove it and skilled enough to know how to remove it. So now we're not talking about a jug of milk anymore with a cap on it. We're not talking about that. Unless you're trained in a special, specific way to open a very complex bottle of milk with a very complex band that seals and preserves its integrity. Think about that for a second. Like it's not a question of shit. Hey man, I bought this milk because I was taking it over to somebody because they asked me to pick them up a bottle of milk and somebody fucking opened it. Who fucking opened it? It's beyond that because it could have been anybody, right? But if that milk, if let's just say there's one adult in the house and then there's like 5 infants, well then it had to have been the adult because the adult is the only one to possess the skills to be able to break that fucking band on the milk. Because an infant's not going to be able to do it. Right? If you pick up a prescription and the prescription is for 500 milligrams of ibuprofen, right? Which I don't know why anybody would steal ibuprofen. I'm just making a point here because I don't know enough about pills. But a 500 milligram pill, 500 milligram pills of ibuprofen. It's in a childproof bottle. There's a teenager in the house who's got a drug problem, and everybody else in the house is a fucking infant, well, then I wonder who the fuck opened the pill bottle with the child-proof cap on it. I wonder who did that. Because make no fucking mistake, people. Make no mistake that Guarino in this analogy is the teenager with the drug problem. Because this dude has a real bad habit of fucking up evidence, doesn't he? Unbelievable. You have to be fucking retarded to think that Karen Reed is guilty at this point.
Oh, here we go.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad.
How dare you?
Oh my gosh. Thank you so much, Nancy Joe M. Very generous. Appreciate that. There was so much late discovery. I don't think anyone really had the time to truly digest all of this evidence. Now, with the benefit of time and Alessi, the defense can truly understand and see the holes that exist in the pros in the previous case. This is, or in the prosecution's case, this is only the beginning. Agreed. And man, that is $100 super chat if I ever fucking read one, because that shit is all facts right there. All facts. Very, 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 very good point right there. Because they have not. This is part of the prosecution's tactics, I think. They're going to get away with not sharing exculpatory evidence as much as they can and push off sharing the exculpatory evidence for as long as they can if they're forced to have to share it. Why? Because it makes the defense it puts the defense at a disadvantage to be able to properly, to efficiently prepare for Karen's defense. It's simple. Like, all of these things are showing. All of these things are in your fucking face. This is the reason why only a fucking retard at this point would think that Karen Reed is guilty. Reasons such as this, because I could go on and on and on talking about the inconsistencies in the prosecution's case, in their tactics, in their methods. I can absolutely do that. I shouldn't be able to do that. Vinnie Politan, should I? I should not be able, with a guilty party, to be able on command to come up with a different inconsistency every 30 seconds if I want to in the prosecution's case. All of these things are not a coincidence. They cannot be a coincidence. And that's not even including the Sandra Birchmore aspect of it all. I'm just talking about Karen Reed. I know Vinny is bursting at the seams. I know this from my balls to my bones that Vinnie Politan his head is going to fucking explode if he doesn't get to say, I think she's innocent very soon. Vinnie Politan is freaking out. I saw it happen. I super chatted him. I posted it on Twitter. I super chatted him and I was like, Vinny, dude, just say Karen's innocent. I know you want to, bro. I know you want to. Just do it. Come on, man. I know you want to. And you saw Vinny reading that out loud going, the glare. Yeah, I know you think that Karen Reed is innocent. I know you want to say it. Just say it. Oh, jeez. Glare. That was Vinny, bro. That was Vinny. Then he freaked out and was like, ah, listen, this case is heating up. And then Vinny did. That's what Vinny did. It was just like, what the fuck, dude? Like, I totally cornered him with that super chat because he's always going to read the super chats out loud. You know what I mean? And he doesn't give a fuck, you know? As long as somebody's shooting him some money, that's cool too. You know what I mean? I'm not shitting on him for that. I'm just saying, you know, like I took advantage of the fact that he was going to read it out loud. I knew he wasn't going to do it. I just wanted to see what his response was going to be. And it was basically fucking exactly what I expected. Talk about. Oh, jeez. I know you want to. Karen Reed is innocent. Glare. I don't. Oh. Yeah. This case is heating up. All right, people. I'm gonna go ahead and wrap this up. That's totally what he did. It's totally what he did. It's fucking hilarious. Peach gifted a membership. Thank you so much. Appreciate you. So nice. So nice. Yeah. I know. I know that Vinny is fucking bursting at the seams because this shit, you can't ignore it. Again. And that's not to insult Vinny because here's the thing is I don't think Vinny's stupid. That's why I say the things that I'm saying right now. I don't think Vinny's stupid. That's why I'm saying that I believe that Vinny is bursting at the seams. Peach gifted another membership. Thank you so much. Oh my goodness. Oh my goodness. That's why I say that Vinny's bursting at the seams because he's not retarded. He knows goddamn well that Karen Reed is innocent. You could tell by his demeanor with Plevin. When Plevin said that fucking shit about the fucking pizza, Vinny was like, I don't like in his mind, he was going, this guy's fucking retarded. And I almost called him fucking retarded. Let me stop myself from calling him retarded. Let me laugh at how retarded he is and then go, I don't think anybody's ordering pizza at 2 a.m, Plevin. I'm sorry, Kevin. That's totally what happened. Totally what happened. Vinny was dying. Vinny wanted to call Plevin a retard right to his face right then and there. I guarantee it. Right now, one of the hardest parts of Vinny's job is not calling Plevin a fucking retard while he's on live on court TV. I don't give a fuck what anybody says. I don't give a fuck what anybody says. I'm telling you right now that I am theorizing that the hardest part of Vinny Politan's job is not calling Plevin a fucking retard live on court TV with Nick Rocco sitting right there. That's got to be. And this is amazing because the prosecution's own witness here, Ian Whiffen, prosecution's own expert,
would you agree with me that somebody who had access to the data before it was extracted and sent to you could have made selective deletions of the data?
Objection.
No, I don't.
Are you aware of an app called MySQL?
Yes.
What is MySQL?
MySQL is just a method for viewing SQLite databases.
All right. If someone had access to the raw data, again, before it was sent to you, and used that app, they could make selective deletions of the data, couldn't they?
I assume you're talking about opening up the extraction, taking.
Right. So the Cerebral Ninja's asking Whiffen here if once you get the raw data, selective deletions can be made, right? You can manipulate it. You can absolutely delete certain things from the raw data, can you not?
Out the particular file and editing it.
I'm sorry, I interrupted you. You're right, Ron. I apologize. And I apologize to you. If you could restate your question or answer.
I love David Yannetti, bro. I love him so much. He's one of my favorites of all time, bro. The Cerebral Ninja. I interrupted.
Oh shit, I'm sorry.
Give me your full answer.
Okay, so it would be possible with the extraction to take out particular databases, alter them, and put them back into the extraction. But there's something called a hash mechanism that we have in place that would it essentially hashes the original data.
I love this guy already, bro. And I'm being sarcastic, but I love this shit. I love that he's sitting here fucking telling the jury right now the importance as to why this was not, as to why there's no way that the original data was manipulated, that the raw data could have been manipulated. And within here is going, well, it couldn't have been manipulated because we have something called hash value. Couldn't have been manipulated. The hash value ensures to let us know that it's been manipulated.
Data, and then it can be hashed again at a later date. It results in a long string of characters, and if there's any changes to the original data, then we'd see that it's been modified.
Would you agree with me that someone with access to that data and an appropriate application or program could also delete and renumber history.db and knowledge.cso so that it would appear as though there was no break in the numbering, so that it would also appear that nothing was deleted?
It's potentially possible, but would require a large amount of knowledge and skill to do in a way that can't be detected.
It would require a level of skill to do in a way to not be detected. Life Laugh, Toaster Bath. You win handle of the day. Thank you so much. Oh my God, before I even read that, you win the handle of the day. We got to give you a round of applause. Live, laugh, toaster bath. I think you've won handle of the day before. This is unbelievable. Guarino should be in jail. Not sharing evidence is one thing, but exploitation is illegal. Shame. Suck it, Grant. Exactly. Suck it, Grant. Yeah, so there you go. So anybody who's listening to this after David and wondering why hash value is brought up and what its function is and what its important is, now you know. So B, the malfunction of the operating system or hardware. In my experience, iPhone hardware and the iOS operating system are very reliable. In this case, there is no data or evidence to suggest that a malfunction of the operating system or hardware caused the deleted record. Now, I don't know a lot about computers, but he's basically saying he's basically in writing troubleshooting what the possibilities for this hash value being deleted and manipulated and this data being manipulated. He's explaining what the possibilities, he's troubleshooting what the possibilities are in writing, in a sworn affidavit, right? And he's basically saying right here at this point, maybe a malfunction, maybe something just happened, right? But now I don't know a lot about computers, but I know that when something goes wrong, my computer detects it. On a computer back in 1999, you could have you hit an option that says troubleshoot and it says blah, blah, blah file is corrupted or blah, 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 blah. Now, this is probably a very, very loose example and from a very uneducated person, and that's fine. But you get what I'm saying. Like, there's ways. The point is that there's ways to detect whether or not there was a malfunction. The computer knows if it's malfunctioned in one aspect or another. The computer has features that are designed to troubleshoot problems within the computer. So there are programs designed to troubleshoot and indicate what malfunction may have took place, if a malfunction took place. And this guy's saying, I ran all those diagnostics. I ran all of that shit. There's nothing that said that anything happened. System application or operating system update. Maybe an update did it. Maybe when her phone updated, maybe that happened. Or maybe when the Celebrite data was updated, right? The structure of databases can change from version to version of the iOS system or associated applications. Upon analyzing Jennifer McCabe's cell phone, okay, so they're talking about her cell phone, not Celebrite or not any of the programs using iPhone, i.e. the cell phone at issue. I was able to determine that the iOS on this device was updated to version 15.21 on January 24th, 2022. This update occurred before the record in question was generated on January 29th, 2022, and would not have been a cause of the deletion. So in other words, the last update happened days, like a week before, around a week before the incident in question. That was the last update. So there's no way that an update came after the Google search supposedly took place that glitched the whole system. Because that's the thing that we ask, right? We go, I don't know. Maybe there was a glitch. That's what we always say, right? Maybe there was a glitch. Or maybe when and then everybody fucking is a computer expert. Everybody's a tech expert and they go, oh, well, maybe when it updated, it fucked up and erased this and erased that. He's saying no, an update wouldn't do that. Actually, that's not what he's saying. What he's saying is, even if an update would do that, it wouldn't matter because the last update that took place happened before the incident in question. So it doesn't fucking matter. Hellfish Haven, thank you so much. Member for 13 months. Green is telling Commonwealth to bite the curb. Yeah. that's a hell of a metaphor there, but yeah. In so many words, you're right. Automated function of the operating system. The artifact in question is found in a write ahead log wall. The data is written to the temporary wall file in order to aid in speed and ensure data integrity. You can think of this as the database being a series of Excel spreadsheets where the data is structured into fields, rows, and columns, and the wall file as a notepad text document where you are quickly adding data that you intend to eventually write into the Excel spreadsheet. The mechanism for writing the data from a temporary wall file to the associated database is called a checkpoint. Now, if you guys remember, I believe that Brandy Churchwell discussed this in her video that she made in regards to the 2:27 a.m. search. Brandy Churchwell, 13th juror, great channel, friend of the channel as well. She's amazing. I believe that she touched on this, if not explained it in theory. I was completely in the dark. I could not handle, I could not process, begin to understand what they were talking about when discussing wall files and hash value and all that shit. At the time, I had no fucking idea. This is making it a lot easier for me to understand. Thinking about it and talking about it over these months are making it easier to understand now, but I still don't fully understand it. But now that I'm reading this gentleman's affidavit, I am getting flashbacks of Brandy Churchwell's video on this and remembering her talking about it. And I am also getting flashbacks, as we saw, of Olivia's tweets. So those are just examples of smarter YouTubers than myself who have been onto this shit for months. And they knew why. Here, with regard to the 2:27 a.m. Haas log to Diane Cole wall file at issue, the data establishes that the last checkpoint occurred on 1/28/2022 at 7:39:03 a.m. Therefore, the deleted state of the 4028 record is not a function of the wall file being written to the database because the last checkpoint occurred the day before on January 28th. I am aware of no internal mechanism for spontaneous record deletion. Doesn't happen. Your shit does not automatically and magically delete shit. And the wall file function isn't even a fucking question because the wall file issue, let me see what it says here. I want to use proper terminology here. Yeah, the deleted state of the record is not a function of the wall file. Because the last checkpoint for the wall file was the day before, was on the 28th. So how could, again, remember people, Jennifer McCabe's phone does not come equipped. I don't remember Steve Jobs doing a presentation saying that one day your phone will have a flux capacitor. And you won't be able to, but your phone and its data will be able to travel back in time. I have been saying this for months based on Brandy Churchwell's explanation, which this guy is basically confirming. The wall file and its checkpoint taking place on the 28th means that there's no fucking way that the wall file just magically deleted something during its checkpoint that took place the day before the incident in question. No fucking way. It's even less likely that would happen at a 6:24 a.m. search. It's even less likely. That doesn't really apply because it's the 2:27 a.m. search that's in question. She didn't delete the 2:20. She didn't delete the or the 6:24 search or 6:34 search. But the fact is that there's no way that the wall file reaching its checkpoint deleted the 2:27 a.m. search from Jen McCabe's phone, or the ghost 2:27 a.m. search that somehow got cloned by the 6:24 search and showed as delete because of the wall file. That shits all over. This right here completely shits all over the Commonwealth's theory and Jennifer Coffendoffer's fucking bullshit and Plevin's fucking bullshit. It shits all over it. And dare I even say Mike King, who, when this issue came up, Mike King was on Court TV, and Mike King's opinion was, well, I mean, that's what the experts say. If the experts say that's what it is, then that's what it is. And I respect the hell out of Mike King. I love Mike King's channel. Although I forgot the name of it already. Profiling Evil. Got it. But Mike King is amazing, and I recommend that you subscribe to him. But the thing is, in Mike King's defense, I guarantee you that Mike King has never seen anything fucking like this. I guarantee that the idea that the Commonwealth, that any local government would go to this extent to railroad one defendant. I seriously doubt that Mike King from Profiling Evil has ever seen that in his entire career. So in his defense, I'm going to give him that grace. Mike King. He has a channel called Profiling Evil. He is a criminal profiler, a career criminal profiler. And he's a published author. He's just brilliant, really. Yeah, he's fantastic. Profiling Evil, yes. He's brilliant. He's fantastic. And I've never met him, but according to my friends Melanie Little and Annie Elise from 10 to Life, they have both met him, and they have both told me personally that he is a very, very nice, awesome guy, that he is exactly the guy in person that you see on his YouTube channel. So I don't think that he had any agenda. I think that he was just asked as an expert to appear on Court TV, and he was like, okay, well, with the very little information that I have on this, then yeah, if the experts fucking say that the 2:27 a.m. search didn't happen because of this wall file and this and this and that, well, then it is what it is. Is he sick? I know that Duty Ron is sick. Is he sick too? Jesus Christ. That bums me out. Mr. Whiffen similarly concedes in his report that he is unaware of any internal mechanism for record deletion. So even this guy basically saying it's possible, sitting on the stand, going, well, you know, but he's sitting there saying there's no mechanism. So in his report, he contradicts his testimony. Deliberate user interaction. Okay, here's another possibility. As stated above, there is no internal field within the browser database to indicate whether the artifact in question was user deleted, i.e. common label deleted with a corresponding entry of yes or no. No such field exists in browser state database. However, as explained in further detail below, additional anomalies found on the phone strongly suggest that this data was either the result of deliberate user interaction or post-imaging manipulation. So there it is. This is the result of him troubleshooting and trying to understand how this data could have been deleted and shown up deleted on every single tool, software tool that Mr. Green used, every single software tool that Mr. Green used to troubleshoot, find out what happened, how did that show up as deleted? Well, they all showed up as deleted. Every single program that he used, it showed up as deleted. And then here he is trying to figure out, well, how could that have happened? Could that have been a system failure? Could that have been an update? What could have caused this? And he eliminated all the possibilities and came to the conclusion that additional anomalies found on the phone strongly suggest that this data was either the result of deliberate user interaction, meaning that somebody manually went in there deliberately and deleted this shit, or post-imaging manipulation. And so we're going to get into the anomalies. My forensic analysis of the image of the Jennifer McCabe cell phone uncovered numerous anomalies or unusual deviations from what is standard, normal, or expected in a typical case. The following anomalies further support the artifact in question was deleted either through user interaction or through post-imaging manipulation. Anomaly 1, the most up-to-date version of Celebrite Physical Analyzer reports 4,560 searches with only one search being marked as deleted. Dude, the only search marked as deleted in the most update version of Celebrite Physical Analyzer is, I'll give you one fucking guess. the Haas long to die in cold search found in browser state record 4028. This strongly suggests that this search was targeted for deletion. I wish I was a fucking mathematician. Seriously, I wish that I was a fucking mathematician, because if I were a mathematician right now, I would work out what the odds were. What are the odds that one? I wonder if I can Google it. Let me see. What are the odds that one Google search is deleted out of 4,000? How many? 4,560. See how smart Siri is. It did not match any documents. So nobody looked into this. Of course, I didn't expect any results, but I was curious, because I wish I was a mathematician. And if I were a mathematician, I would love to work out that probability. What are the odds that that particular Google search out of 44,560 was deleted? The one Google search that we're all focused on was deleted. Well, yeah, I mean, 1 in 4,560 would definitely be the simplest way to put that. I guess it doesn't take a mathematician, does it? Guys, when I tell you I'm stupid, I'm trying to tell you I'm fucking stupid. Okay? You guys don't seem to get that shit. Anomaly number 2. The tab ID for record 4028 is blah, 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 blah. This number is unique to the tab in question and would have been used for all URL history in that specific tab within this particular database. The Commonwealth has claimed that the actual website being visited during this period was hockamocksports.com. However, the tab ID recorded at 2:27 and 36 seconds AM associated with the hockamocksports.com web activity has a different tab ID number, specifically blah, 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 blah. Thus, the records in question clearly established that the hockamocksports.com activity was conducted in a completely different tab than the search for the House Long to Die in Cold, which also showed activity at 2:27 a.m. just seconds later. So right there, he's proving that this is probably my favorite part. This is probably my favorite part, because he proves right here. He's like, that right there is data proven. It's data proven. It's not even like, oh, one expert versus the other. Bullshit. No, this guy can prove with data through a sworn affidavit that there is a tab, there is an ID number for each tab. And Jennifer McCabe tried to say, and the Commonwealth tried to say, that the 2:27 a.m. Google search for House Long to Die in Cold timestamp was confused with the 6:34 House Long to Die in Cold search, because she at 2:27 a.m. she actually Googled about her daughter's basketball scores, or Googled basketball scores. right? Not her daughters, but Googled basketball scores. I think it was her daughters. I could be wrong. That doesn't matter. But she was Googling basketball scores from this, what do you call it? HawkMonkSports.com. And that's why the wall file confused the 6:34 House Long to Die in Cold timestamp with the 2:27 timestamp, because of the search that she made Googling sports. But this man is saying couldn't have been, because it was a completely different tab. Wasn't on the same tab. There are different ID numbers for each of the tabs. I love that. Thank you so much. That's awesome. I appreciate that, Breakdown. See, you guys, this is why I love my chat. You guys are fucking fantastic. I learn so much from you guys. You're so interactive. Look at, there's no fucking way. $0.000219%. Come on, man. Jen McCabe totally Googled House Long to Die in Cold on January 29th, 2022 at 2:27 a.m. and deleted it at 2:27 a.m. and 40 seconds. That fucking happened. Stop it. So this anomaly that he's saying, it's not an anomaly. I mean, this it's an inconsistency. It's a blatant inconsistency. It doesn't take a text expert to realize this. There's two different tabs because they have two different ID numbers. Those ID numbers indicate, they identify, that's why they're called ID numbers. They identify each tab. So if there's two different ID numbers indicating two different tabs, then how could the timestamp be confused? By an anomaly, by the way, by something that just doesn't happen. That was also established by Ian Whiffen. Think about that shit. Anomaly number 3. The Commonwealth's experts, Ms. Hyde and Mr. Whiffen, opined that the 4028 record with the 227 timestamp initially would not have been associated with the House Long to Die in Cold search. I have examined the multiple rights of the 4028 record contained within the browser state wall file, and in all instances, the URL containing the House Long to Die in Cold was present. I see no evidence of the 4028 record containing a different or blank of that field. Wow, that's weird. So why would they say that? Why would Mr. Hyde and Miss Hyde and Mr. Whiffen opine that the 4028 record with the 2:27 a.m. timestamp initially would not have been associated with the House Long to Die in Cold search? Why not? I've examined. See, I'm confused as to what the Commonwealth experts are trying to convince anyone of, because they contradict themselves constantly, it seems. And he's examined multiple rights of the 428 record contained within the browser state wall file, and in all instances, the URL containing the House Long to Die in Cold was present. Every single one of them. I see no evidence of the 4028 record containing a different or blank for that field. So it would show up blank, is what he's saying. He's saying it would show up blank. based on what the Commonwealth experts are trying to say, that if they don't associate with that field, then that space in 227 at the time frame of 227 would show up blank. It does not show up blank. Not according to the 5 different tools applied by the defense's expert. The search artifacts associated with how long to die in cold, 227 and 40 seconds a.m. How long T die in Kaikid at 6:23 and 51 seconds a.m. and how long to die in cold at 6:24 and 18 seconds a.m. are all missing information that would be expected in the history file. Mr. Whiffen opines that the load was likely never successful as it was never populated in the history database. However, the Google suggestion artifact for how long to digest food appears at 6:23 and 49 a.m. along with a picture. This indicates that the cell phone in question had internet connectivity at the time of 6:24 a.m. search and contradicts Mr. Whiffen's speculative suggestion that the load did not complete. Okay, so that's what the Commonwealth is trying to say. They're trying to say that the reason why it's showing up at 6:24 a.m. and not 2:27 a.m., or sorry, that it's showing up at 2:27 a.m. and not 6:24 a.m. is because the Google search that she conducted before in that window didn't finish loading. That the window didn't finish loading. So the fact that she searched other things, she searched for something else at that time, means that she had internet connectivity, which means that she had service. And there's no reason that that would have not shown up. There's no reason why that would have not finished loading, is what I mean to say. Do I think that the prosecution talked with the jurors and they know what was hanging up the verdict? No. Like, listen, I realize that a lot of this shit is just so fucking unbelievable that it's even hard to accept, because it's like this shit doesn't happen. But some of you guys come up with some shit that there's no way it would happen. Like, there's just no fucking way. Like, the reason why you have to follow the evidence. Okay. The reason why I don't think that happened. Now, I'm not saying that I wouldn't put it past the prosecution to do something that low and unethical. I wouldn't put it past them. But the jurors coming forward on their own, of their own volition, after the mistrial was called and saying, hey, it's important. I think we need to know that 2 of those counts, we voted unanimously that she was not guilty. 2 of those counts. Now, if they came forward and said this in those 2 interviews that Turtle Boy, Aiden Carney, conducted with 2 of those jurors, I guarantee you this would have come up. If the prosecution talked to the jury or talked to the jurors, that is completely unethical. And the jurors would have been like, well, yeah, you know, Lally came in and talked to us and blah, 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 blah. The only person that could talk to the jurors at all is the judge during deliberations. The only person that can communicate with those jurors is the judge. And the bailiff to say it's lunchtime. What's up, Mazza Media? It's good to see you, buddy. Congrats on 10K, my man. Mazza Media most deservingly has reached the 10,000 subscriber mark. And that's a hell of a That's a yeah, man. That's it's a hell of an achievement, man. Well done, dude. I think you deserve more, but I think you deserve at least 39,000. But 10,000 is definitely nothing to shake a stick at, man. It's definitely a milestone to be very proud of. And I love you, buddy. Glad you go. I'm glad that your channel's growing most deservingly. We all appreciate you and everything you do, man. Now, anomaly number 4, the search artifacts associated with How Long to Die in Cold. I already read that. Sorry. The load was likely never successful as it was never populated in the history database. The load was not successful is what Mr. Whiffen opined. But what Mr. Green is opining is that the fact that she Googled successfully how long to digest food at 6:23 and 49 seconds a.m., along with a picture, because it takes more internet, it takes more bandwidth to load a picture. It indicates that there's no reason why a load for a Google search would not be successful for something that simple. When a Google search that comes back with a picture happens 1 minute before the other searches. Bullshit. This indicates that the cell phone in question had internet connectivity and that the time of the 6:24 a.m. search and contradicts Mr. Whiffen's speculative suggestion that the load did not complete. So Mr. Whiffen, being an expert, he really didn't think this through very well, especially since his own software that he developed himself was used by the defense's expert and reached the same conclusion that Jen McCabe absolutely Googled how long to die in cold at 2:27 a.m. and tried to delete it. His own software indicates this. The knowledge information for the How Long to Die in Cold search appears to be out of order. Knowledge C artifacts typically run a few seconds after the event in question. For example, the plist time, I don't know what that word is, for How Long to recorded the worst typed one, recorded at 6:23:51 a.m., has a corresponding knowledge time entry of 6:23:57 a.m. 6 seconds later. Typically, the knowledge artifact appears second after the plist entry. However, the 6:24:18 a.m. plist entry for How Long to Die in Cold is followed by a knowledge C time of 6:24 and 24 seconds. 6 seconds later. For how long tie-dye and the corresponding knowledge C entry for How Long to Die in Cold does not show up until hours later at 10:35 a.m. This is unusual and deviates from what is typically observed. That's crazy. Okay, so that's weird. Yeah, the corresponding knowledge shows up just a couple of seconds later. But for some reason, the corresponding knowledge for How Long to Die in Cold doesn't show up until hours later, 10:33 a.m. I was trying to understand that better, but Trooper Nicholas Guarino's April 24th, 2023 report shows that he took custody of the phone on 2/2/22, February. So just a couple of days, just a few days after John O'Keefe is pronounced dead. he gets this at 12:08 p.m. However, the gray key log indicates that the device was not accessed for imaging until 2 hours later. At 19:25. Okay, so in military time, that's what? Okay, so yeah, so he gets 2 hours later. He gets a hold of the device. He took custody of the phone at 12:08 p.m., but doesn't try to access anything in the device for 2 hours. Or converted locally. Yeah, if I would have just scrolled down, it would have translated that for me. The report also indicates he was even given the password to the phone. Nowhere within the report does it explain the time delay between receiving the device and imaging the device. Oh, okay. I see what he's getting at here. He's saying that Guarino failed to report the time difference. Cheryl with an S, member performance, ever debated the insufferable boundless millennial? I covered his stream. The problem is he's so fucking boring. You know, I did a petty stream last time and I went over his live stream and I was like, this guy's a fucking retard, dude, and he's boring as shit. Fucked up my show. So here it says the report also indicates he was given the password to the phone. So he gets the password at 12:08 and so and it's not accessed for imaging until 2:25 a.m. 2:25 p.m. Huh. So he's pointing out that Guarino failed to put this difference in his report. This time difference. It is my opinion, based on a reasonable degree of scientific certainty, that the 2:27 a.m. 40 search artifact for Haslong to die in cold was deleted by either deliberate user interaction or manual post-imaging manipulation of the data by some unknown individual. The methodology I used to elevate the 2:27 a.m. search artifact for Haslong to die in cold, as described in this affidavit, is generally accepted to the digital forensic scientific community and is consistent with applicable National Institute of Standards and Technology guidelines as shown in digital investigative techniques. In other words, I'm qualified, and is attached as Exhibit B. So this is fascinating. Now let's talk a little bit more about this for a second. The reason why that's significant, that 2 hour window between when he receives the phone at 12:08 and then accesses the imaging 2 hours later. What that does is that will tell a jury that he could have manipulated the phone in that window of time. Maybe, I don't know. Maybe that's what he's trying to get at. I'm not sure. I'm just thinking out loud here, folks. I don't know. But the bottom line here is what is it going to take at this point? What the fuck is it going to take for this to stop? What is it going to take for Judge Bev to finally go, okay, this is enough? See, I'm of the opinion that this should have happened a long time ago. The prosecution has never had a case. And going into a second trial, which clearly shouldn't even be happening, the prosecution has even less of a case. And it is glaringly obvious that the defense or the prosecution's entire approach to this case is to try to block the defense from having a defense. A prosecutor should be like, hey, man, do your worst. Bring in all the experts you want. We have experts that we know are going to tell any juror with any common sense whatsoever that she did this shit. That our facts are going to supersede your smoke and mirror show. That's what a prosecutor's approach is always and should always be. If you're acting in the interest of justice and in pursuit of the truth, this is what you do. But instead, it's the prosecution that's putting on this smoke and mirror show. It's the prosecution trying to block the jury from hearing the defense. How is that not suspicious? This goes beyond the whole concept of beyond a reasonable doubt. This begs the question. It pleads the question. Why is this case moving forward when the prosecution, their only strategy is to block the defense from having a defense? Why aren't they confident enough in their case? Why is the defense filing opposition motions instead of filing motions to try to block the prosecution from being able to present evidence? Because that's usually how that works. At least to my understanding, in my experience of following trials, I've seen the defense doing everything they can to try to block the prosecution's case from being presented. They'll file motions saying, we don't want this evidence entered. But we're not seeing that from the defense in this case. They don't give a shit what the prosecution presents. They don't care. They're like, do your worst, knock yourself out. But what they're doing, what the prosecution's doing, is hitting under the belt. Underhanded dealings. Trying to stop the defense from presenting their evidence. That's what they're absolutely focused on. All that tells me is that Karen Reed is innocent. Essentially, that is what that tells me. Not only does the prosecution not have a case, but they are protecting the guilty party by trying to railroad the innocent party. Because otherwise, if they weren't trying to protect the guilty party, why wouldn't they just say, hey, you know what? We don't have a case. That's it. We don't have a case. Because the courtroom's not filled up with Boston cops, and the streets aren't filled up with Boston cops going, fuck that. We want justice. We want Karen Reed convicted. She's a murderer. She killed one of our brothers in blue, and we want justice. That's not happening. So why don't say that there's public pressure to convict Karen Reed because there is no public pressure to convict Karen Reed. Now the pressure has shifted to exonerate Karen Reed. The public pressure has shifted. The weight right here. Karen Reed, exonerate her. Let her go. Free Karen Reed. Absolutely outweighs. On the scale, boom. Absolutely outweighs anyone demanding justice for John O'Keefe by means of convicting Karen Reed. So that would be the only thing that would make sense of why the Commonwealth is so adamant about convicting Karen Reed with such little evidence, with no evidence. Moving forward with this case, it would be the only justifiable, or at least I wouldn't call it justifiable, but you know, remotely justifiable reason would be that there's public pressure. Because the facts indicate that Karen Reed is guilty and they need to prove it. But the facts don't indicate that Karen Reed is guilty. Now, this is the lie that the Karen Reed haters and the haters of all of us have convinced themselves of. That's the lie that they've convinced themselves of. But the fact is that the majority of public pressure is in favor of Karen Reed being exonerated. And the reason why that is because the facts simply dictate that she is innocent. And the only confusing thing about this now is why this trial is moving forward. That is the only thing that begs the question at this point. Why is this trial moving forward? If all of the facts dictate that Karen Reed is innocent, if all of the facts dictate that there is absolutely no fucking way that this prosecution is going to convince a jury beyond a reasonable doubt that Karen Reed is guilty of this crime, if all of those facts indicate that, then why is this trial moving forward? Why is Judge Bev moving forward with this trial? The only logical answer is corruption. The only logical conclusion is corruption. That's it. The only logical conclusion as to why the prosecution, since the possibility of meeting the public's demands is out, the only conclusion left as to why the prosecution is continuing to prosecute this case is because they're trying to protect the actual guilty party. And there is so much information to indicate that there is motive to protect said guilty parties. The connections between Auntie Bev and the McAlberts, the connections between Trooper Proctor and the McAlberts, the connections between Trooper Dunn and the McAlberts. The connections between Officer Lank and the McAlberts. I mean, that's your motive right there. It's not like there's one questionable connection between the McAlberts and somebody who plays a major role in this investigation. It's not like there's one little thing. There's way too many to ignore. Way too many to ignore. And the bottom line is the Commonwealth fucked with the wrong woman. That's what's going on here. They fucked with the wrong family because this family went and hired the strongest defense team possible, who's not afraid to address something that seems far-fetched because they have enough evidence to show that this is not far-fetched, that this woman is 100% being railroaded by a local American government. There is no mistaking this.
Oh, here we go.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad.
How dare you?
M. Fetters, thank you so much. You have been on fire tonight, and I am here for it. Love me some spicy Will. You are an amazing human being, Will, inside and out, and Massachusetts is blessed to have your support. I'm blessed to have Massachusetts support. Thank you so much for that. That means the world. Thank you. Yeah. So, yeah. So, I mean, at this point, it's a question of what are the feds waiting for? Now, I'm not saying that as criticism to the feds. I'm saying that out of pure curiosity. I'm wondering what they're doing. I'm wondering if there's so much more to this that we just are not privy to, that they're aware of, and that they're investigating that's causing them to hold this off. Because we cannot live in a country where this is blatant in everyone's face. And justice for the murder of a Boston police officer is not being pursued, is actively being avoided. This can't be real life. This doesn't fucking happen. This is the kind of thing that I am confident. And I'm not even one of those people who love Trump and Trump can do no wrong. And, you know, I'm not one of those radicals who fucking just love Trump. But this is definitely, based on what I've seen about Donald Trump, this is definitely one of those things that I am convinced at this point that if Trump were to be made aware of the details of this case, he would make it a personal fucking project to make Norfolk County and Michael Morrissey an example of the kind of corruption that is not going to be tolerated in our justice system. I believe that. I believe that. I believe that if Donald Trump, if the country was running in a perfect manner, and Donald Trump had time and he was just sitting around scratching his balls, and somebody goes, one of his advisors goes, well, there's this thing going on in Norfolk County, Massachusetts, you might want to take a look at. Massachusetts? What's going on in Massachusetts? Why do I care about Massachusetts? Because, well, there's like blatant corruption. And then his advisor would have to be like one of us and then be like, dude, you don't even fucking know. I don't even know where to fucking start, and start talking to Donald Trump about it like I was talking to Hannibal and Monty. And then Trump would just be like, oh, yeah, that Jen McCabe, she's dirty, yeah? Yeah, she's dirty. All right, we're going to put a stop to her. We're going to put a stop to her immediately. She's a very bad person. She's not good. She's not a good person. It's very disgusting. And unattractive too. She's very unattractive. I guarantee you that's what would happen. I guarantee it. Yeah, you're right, Microdots. He would like her. He'd look at Nicole and Julie and be like, what happened to them? Did they he's very, very unattractive, very ugly. Very ugly. No. I would not be grabbing either one of them by the pussy. He would say Julie did it. Jesus. Somebody stop giving this girl meatballs. Okay? Stop it. No more peanut butter and jelly for her. She totally did it. Well, you know, those lesbians, they're angry people. They're very angry people. My money's on her. My money's on the lesbian. Oh my God. Like, I'm just having fun picturing Trump like having these strong Twitter-like opinions on this case. Like being hyper focused on it. Just tweeting shit like Chris Albert is a disgusting human being. His pizza is beyond mediocre. I had his product. It's not good. I mean, think about it, dude. Like, that would be a fucking, like, that would be like winning the lottery for everyone here, is if Donald Trump himself took a personal interest in this case. I would fucking love it. Like, I would be like, that's it. I could die. Just let me get through the closing of this. I could die after that. I'll be fine. You know? Like, I've already seen, even though it was shitty, I've already seen a Batman versus Superman movie in my lifetime. I wanted to see that my whole life. I got it. It's cool. Just let me live through Donald Trump getting wind of this case. Please. That would be so funny. Oh my God. That would just be so funny. Yeah, but Turtle Boy, he's something else. He's something else. Turtle Boy's a real American. He's doing everything he's supposed to do as a journalist, and oh my God. And my Trump impression is horrible. Like, I've never worked on it. I can't do it. I'm just picturing out loud how I would picture him absorbing the information in this case. He would love Turtle Boy. What are you talking about? He would absolutely love Turtle Boy. Turtle Boy is a great American. Crusader for everyone's First Amendment rights. Right. Yeah. Yeah. Same here. Like, I mean, but I got it though. You know what I mean? I got a Batman versus a Superman movie. It's a great idea. I was pissed about Ben Affleck being cast. Still pissed about Ben Affleck being cast, even though he did grow on me a little. But even still, I still watch it today and go, like, you ever watch a movie like 10 times that you didn't like simply because you wanted to like it so much? That's literally every DC comic book movie that in the Snyderverse. Yeah, I don't like his acting either because his strongest acting would require him being Bruce Wayne. He was a terrible Bruce Wayne. There was no difference between the character of Bruce Wayne and Batman. There was no difference. Like, the whole point is, like, he's supposed to act like a spoiled, drunken, stupid billionaire, who nobody would ever suspect would be Batman at night. That's kind of the whole idea. Not some brooding, dark guy who's like, you know what? That guy's pretty pissed off, man. Like, my brother-in-law was trying to steal a purse, and some dude who acted just like that guy beat the shit out of him, and he was dressed like a bat. And he had some really expensive equipment. I don't know anybody else except that guy that could afford that kind of equipment. It would be that easy, That's the whole point. That's why, yeah, Christian Bale was the worst Batman, but the best Bruce Wayne, because Christian Bale did this. Christian Bale had the spoiled white guy lisp, Rachel, fancy that. that was perfect Bruce Wayne. And then Batman was just way overboard. Like, Batman was just, I'm breathing through my mouth the whole movie, and I'm supposed to be intimidating. I couldn't stand it. Every comic book I've ever read, Batman is sitting there like this with his mouth closed. Mouth is closed. That's it. He's not a mouth breather. Bothered the hell out of me. Still bothers me to this day. But the movies were great. Very well written. Extremely well directed. Everything about the Christopher Nolan trilogy is fucking perfect except for Christian Bale's Batman, in my opinion. Oh, is there someone spamming? There you go. Thank you. Okay, now you can stop spamming. Appreciate it. I also kind of want to go over. I reposted a couple of things for the purpose of going over them. Give me 1 second here. Oh, and let me do this real quick. If you guys, oh shit, I didn't mean to do that. Oh my God. Now my search history is going to be all fucking wonky. No, it's not. Oh, snap. Okay, here we go. All right, now make sure I'm dropping a link in chat. I'm going to pin it to the top too. If you guys are feeling generous, please make sure to donate to Karen Reed's defense fund because she needs our help. The only thing that is providing her with the means to be able to fight an entire local government trying to frame her is us and her attorneys. And the reason why it's us is not just because of the moral support that we provide, but because we can help provide the very limited resources that is her defense team. And she's almost out of money, y'all. And this is their tactic, is to drain her resources. And this is why Karen Reed needs us more than ever now, guys. So please donate to Karen Reed's defense fund if you can. Any amount helps. Nick Rocco is also promoting a dinner giveaway. $50 per entry gets you a chance to make sure to send me a screenshot on Facebook. It gets you a chance to sit down, and let me explain what this is. $50 entry gives you a chance to sit down with Karen Reed and Alan Jackson. And there are 348 entries now. So you have a 1 in 348 chance of winning. Like the math I just did there. You have a 1 in 348 chance of, which is a pretty good chance of winning a sit down dinner with Alan Jackson and Karen Reed, and to pick Alan Jackson's brain, which is what I would do. That would be amazing. So, oh, sorry. That's actually not correct, because there will be 2 winners. So your chances are even better. Your chances have doubled. Well, not doubled, but your chances are even better. I mean, dude, you're right. I'm fucking stupid as fuck. I'm trying to tell y'all. You guys don't fucking realize I'm fucking stupid as fuck. But yeah, make sure to donate to Karen Reed's Defense Fund, because even this fucking idiot could tell you that Karen Reed is 100% innocent. And even this fucking idiot can tell you that Karen Reed needs our help as much as possible. Okay? Because money doesn't grow on trees, and having a defense team like that, and you know, hitting those curveballs over the fence that the Commonwealth keeps throwing at her costs money, money that she's running out of. So now more than ever, this is the home stretch, guys. This is the home stretch. Now, this guy Ted posted something here. Think Celebrite is going to love hearing this being argued in a courtroom in arguably the biggest case in our country right now, arguably. Hearing that their database program was manipulated through some black box process in the back room of Celebrite, that Ian Whiffen and Celebrite labeled this mysterious process an update, that the defense expert Richard Green won't play along with the manipulation of the Celebrite program. That means if it could be proven that Ian Whiffen did this, if it could be proven, then Celebrite is going to be put in a position, in order to maintain credibility within the law enforcement community and the legal community, they're going to have to put out a statement disassociating themselves from this fucking dickhead, Ian Whiffen. That's what's going to happen. This is going to have to happen. And that their main competitor, Magnet Axiom, which Jessica Hyde used initially as well, did not make any changes to that same timestamp, except for making it more accurate by going through 3 decimal places past the second 227 point. 0.465. 227. So the exact time is 2:27 a.m. and 40 seconds and 40.465. So made it accurate, more accurate. And this dude said, "Holy shit!" And this user is named he goes by T Clubber Lang 69. I love that. So a Rocky reference and calls himself Ted from the movie Ted. $100 says Whiffen doesn't have a job at Celebrite by the start of the trial. He's done too much damage as is. He's toast. And Jessica Hyde took a flamethrower to her reputation too. Care to explain that updated report, Jessica? That certainly doesn't seem industry standard, using only one forensic tool when you initially used 5. Yeah. Bob Alessi's cross-examination of these 2 expert witnesses cannot come soon enough. I love that. I love that. Yeah, this is a big deal, people. Now, I also love Microdot's post here. I reposted this. So remember, I was trying to do that math so you can have a visual in your head of what the chances are that Google search would be, out of all Google searches, would be accidentally deleted by through some malfunction in Jen McCabe's iPhone, or through some malfunction in Celebrite, right? Remember? So Microdots did this. This is why one of the many reasons I love Microdots. Now, if you look closely, what you can see here is that's 4,560 searches, right? Each one of these little gray dots is one of those searches. So a whole panel of these. See these? These are 4,560 searches. And here, right here, this little red dot right here is the Haslong to Die in Cold. And that was the one search out of all of these. The one search out of all of these that was deleted. Explain that shit. Explain that shit. Another coincidence, right? Another coincidence. I know, buddy. We're almost done. You guys see why I took that little intermission before? Because I knew this was going to be a long stream. And I appreciate you guys hanging out with me for this long. This is literally 2 hours longer than I normally would go. And let me see if there's anything else that I had reposted that I wanted. Yeah, that's it. Other than like political stuff. Oh, okay, never mind. We have to go over this. This is a must. Who, I have to credit the right person for this. Shawnee Sean on Twitter or on X did this. This is for your viewing pleasure. Oh my fucking god, bro. So stupid. It's simple as stupid as shit, but it's so funny.
Now, and Tom doesn't.
Spider.
Spider.
What
It's not even over yet.
Well, otherwise you're just a pain in the ass that's ignoring evidence, and I'm sick of it.
Pain in the ass that's ignoring evidence, and I'm sick of it.
I'm sick of it. This is why I say it. So this Bibba bitch, you dumbass cunt.
My God. Let's watch that one more time because I'm petty. So fucking funny. The stupidest shit ever, but it's so funny.
Yeah, we talked about that, Nick Rocco.
Let me see if I can find that. Look at this motherfucker, dude. Like, how are you supposed to take this guy seriously? Vinny, this is your boy. Come get your boy, Vinny. Vinny Politan, come get your boy, please.
Spider.
Spider.
Well, otherwise you're just a pain in the ass that's ignoring evidence, and I'm sick of
Pain
it.
in the ass that's ignoring evidence, and I'm sick of it.
I'm sick of it. This is why I say it. So this Bibba bitch, you dumbass cunt.
Jesus Christ, Flevin. Oh my God. That's so funny. Hold on. I know that Aiden posted a couple things that I wanted to talk about. He made some points. Well, Aiden reposted Andrea Burkhart's post here, which I want to read. She's a law tuber. And she says the Commonwealth is plainly abusing the Daubert-Lanigan motion. Mr. Green is evidently qualified by training and experience. His opinions are based on interpreting digital artifacts ordinarily relied on in digital forensics, and he stated multiple specific facts supporting his opinions. As with Dr. Russell, the state's remedy for what they perceive as Mr. Green being wrong is to convince the jury with their own experts. Judicial gatekeeping would be highly inappropriate here, and the motion will be denied. See, I didn't even know. I did not know. Well, I did know. We all knew this. Judicial gatekeeping would be highly inappropriate here, which is what Bev would do if she approved this motion. But it's highly inappropriate. And Andrea Burkhart is confident that it will be denied. I wish I shared her confidence. We know that it should be denied, but coming from Judge Bev, who the fuck knows? Who the fuck knows? Yeah, I'm just trying to see if there's anything that I didn't already go over. Okay, yeah. Oh, yeah, this is fun stuff. So, Carrie Roberts' sister-in-law. This is interesting. Carrie Roberts' sister-in-law donated $249 to Karen Reed's legal defense fund on the anniversary of John O'Keefe's murder. Carrie didn't kill John O'Keefe, but she's arguably the most pathetic person in this entire affair. Arguably, yeah, absolutely. So the note says here, because it's very public, the note says here in Karen's defense fund link, Karen and family praying and supporting you 100% always. This is Carrie Roberts' sister-in-law. Karen and family praying and supporting you 100% always on John's anniversary. I remember a good family friend and remember meeting you, Karen, a few times at family parties. I miss John And when you are set free, Karen, the true murderers will be charged and John will finally have peace and justice. Sending much love and support. Wow. And Esty, during the live stream that the 24-hour live stream that was held by Seeking Justice with Tom and Mike, Esty was on that panel and she commented, she was saying, I was reading Karen Reed Defense Fund donors live on Tom and Mike's channel. I read Tara's donation. We all had a cry. And then she wrote in the chat, it was beautiful moment. It was a beautiful moment. Thank you, Tara, for speaking up and sharing. You know, Karen is innocent. I'm in awe of you and truly believe you have a pure, honest heart, and you know how important it is to tell the truth, even if your family can't or won't. Well said, Esty. Absolutely. Well said. Because that is a beautiful, beautiful moment. That's a beautiful thing. This woman is in the heart of it. And here she is publicly showing her moral support as well as her monetary support to Karen Reed, professing that she believes her to be innocent. And that is a risky thing for Tara. That is a risky position for Tara to publicly take. And I am I'm going to go ahead and publicly commend her for that. Well done. Thank you for that. You're amazing. Carrie Roberts' sister-in-law. Unbelievable. Again, people, at this point, if you believe Karen Reed to be guilty of this crime, you are fucking retarded. I'm not going to pull any punches. And let me give you guys a quick reminder. I don't want to. I hate to leave this on a negative note, but let me give people a reminder because I continue to get these messages. Let me save you guys some time. If you're new subscribers, let me save you some time. I like to use the word cunt, and I like to tell people to go fuck themselves, and I like to say fuck off to people who I deem fit to tell fuck off and to go fuck yourselves to, and who I deem fit to call a fucking cunt. If this is the kind of thing that makes you uncomfortable, this is not the channel for you. Okay? I want to be very, very clear about this. I don't want to mislead you in any way. Okay? So moving forward, and what makes me angry about that is not that somebody is bothered by those things. You're allowed to be bothered by whatever you want. What bothers me about it is that you think that you get to tell me what to do. Here I am talking about free speech all the fucking time, and you think that I'm going to take your suggestion. Glamour, I think you're awesome, and I really love you, and I love supporting you, but, you know, you're just so nasty sometimes. Yeah, I'm a nasty motherfucker, dude. I am a nasty motherfucker. Let me be abundantly clear with you. I have absolutely every ability to be the nastiest motherfucker you've ever fucking talked to. Guaranteed. The most insulting or rude motherfucker that you've ever spoken to. Guaranteed. I absolutely have that in me. And if you want to label me a child abuser or a woman beater, I don't care. I don't care. Like, if you are so glued and hanging on every word of someone who you are so convinced is such a shitty, fucked up, immoral person, well, then there's something wrong with you. Because if there's somebody who I know to be like that, if there's somebody who I believe to have these as personality traits that define their character, if that's the kind of person you are, I'm just not even going to bother with you. I'm not going to pay attention to what you have to say. I'm not going to give a fuck what you have to say. I'm going to immediately dismiss whatever the fuck you have to say. So if you have these opinions of me and you're hanging on my every word, there's something fucking wrong with you, not me.
So, you know, show me an actual police report or a charge that says I ever put my hands on a woman. Show me one. Now, I have admitted to disciplining my son physically. But here's the thing about that. I don't have anybody to apologize to about that except for him. You motherfuckers, I don't owe the slightest apology to you. I don't have to justify my actions to you. You can fuck off. If this is something, because I don't feel the need to explain my personal family business to you beyond that. There was a time, the only reason that I admitted that in the past is because I was accused of it, and I believe in taking accountability for my actions. But that's understanding the fact that you could take that information and form an opinion of me with it if you like. That's absolutely, that's your right. That's your business to form an opinion of me based on that information. But any information beyond what I've already shared is none of your fucking business. It's personal family business between me and members of my family. You can go fuck yourself. I owe you no explanation. I owe you no apologies. I owe you no justifications. Go fuck yourself. You make absolutely no difference by posting ridiculously fucking half-ass typed bullshit put out there by my ex. You have no, I mean, you make no impact. Absolutely none. So anybody who thinks, in lieu of all of these things, since you all have all of the information that you need, in lieu of this, you are free, of course, as anyone, to form a personal opinion of me. But if you continue to watch and listen and follow me on social media, well, then there's something fucking wrong with you. You're the one with the problem, not me. Because my actions, my current actions, are what dictate my character. And I'm proud of the person that I am right now. Extremely proud. We all have things that we've done in our lives that we may or may not be ashamed of. But the fact is, the fact is, how you conduct yourself, at least me personally. Again, you have the right to do whatever you want. Me personally, I judge character by consistent actions that I see presently. That's how I judge character. So, if you want to label me these things, that's your right. That's your business. I don't give a shit. I'm not trying to run for fucking political office. I don't give a fuck what skeletons come out, because I'm content with the person I am today. I do not give a fuck, literally, what skeletons about me come out. The only time I would ever give a fuck is if they would somehow embarrass someone else that I'm close to. That is the one line. But anything that would only embarrass me, maybe, I've got no problem talking about or admitting to. I take pride in my self-awareness, and I take pride in my sense of accountability. And that has led me to be the person that I am now. So, again, you're free to form your own opinions. But, that's up to you. But just know that the only thing that bothers me when you have these opinions
is you telling me or trying to control what I say. Because all it shows is that you, A, have no argument against what my opinions are. You have no sound ground to stand on. And B, that you're just trying to shut me up because you're afraid of what I have to say. That's all it tells me. And the truth is, I get a little satisfaction from that. Every time I see this Glamaboos person on Twitter, I'm like, oh, there she is. I don't give a shit about these things that they post. I don't give a shit what you think of them. I mean, yeah, like everybody on the Karen Reed is guilty side, everyone on that side, they have no facts. Their whole method of arguing with you about whether or not Karen Reed is guilty is to dig up your past and manipulate the facts in it, or just fucking straight up make shit up. Like, that just tells me everything I need to know about Karen Reed's innocence. That's how that speaks out. Right. Yeah. Low lifes hiding behind troll accounts, low lifes. Like, dude, if you don't, you have no business pointing out anyone else's physical imperfections or personal imperfections in their personal life. You have no right pointing that shit out under an anonymous, like, you have no credibility. It's not coming from a real person. It's coming from a fucking from a fucking uncreative fucking handle and a dumb fucking looking avatar. And that's it. Like, that's how little impact it has. Like, if Microdots, and I'm only using him as an example because he's in the chat right now, and somebody who I respect very much, if Microdots were to go, hey man, this and this shit about you, I heard, and I don't think I could fucking fuck with you no more, dude. It would hurt, but I'd get over it pretty quick. Because I'd be like, that's your fucking problem. Ultimately, I would be disappointed and hurt because I like Microdots and respect Microdots, but I would get over it quite quickly. Imagine what kind of impact a fucking stranger with a fake avatar and a fake handle has on me. So, and yeah, and sometimes there's going to be a little drama. Like, there's still a little drama going on Twitter. And here's the thing is just save your fucking breath, because I don't want to hear you fucking complain about it. Just save it. Just save your typing fingers energy, because I don't want to hear about it. It's real simple. Just don't look at the fucking post. Pass the post up. Unfollow me on Twitter. I don't give a shit. But if somebody is going to passive aggressively start whining and bringing things up, and passive aggressively not mention my name, but they're clearly talking about me, well, then I'm going to point out that cowardly behavior. It's just in my nature. I'm going to do that. I'm going to be like, fuck this asshole and fuck his passive aggressive pussy ass. Fuck him. That's what I'm going to do every time. If this is something that bothers you, fuck off. But for some reason, there's this stigma. Like, I don't understand. Like, you guys in the chat, you subscribers and you followers, you guys have a right to your opinions and feelings about us and express them, but we're not allowed to express our opinions and feelings about each other as creators. We're not supposed to do that. We're not allowed to do that. Where's that? What the fuck is the where's the logic in that? Oh my God, I just don't understand. This is so bad for the movement. How could you? Shut the fuck up. Mind your fucking business. If it's bothering you so fucking much. Oh, this is too much. Oh, Glare. I like both you guys. This isn't fair. I'm not telling anybody to fucking unfollow anybody. Other than me. If you have a fucking problem with what's going on, unfollow. But I'm not telling you, trying to influence how you feel about somebody else. I'm merely going to defend myself against this person who's clearly talking about me and just acting like a pussy and not fucking naming my name. So I can't defend myself against that. Somehow I'm because I'm not the bigger person. I'm disappointing to some of you. Let me let you know a little secret. I'm not the fucking bigger person. I've never been the bigger person. In fact, I'm not even sure it's in my fucking DNA to be capable of being the bigger person. I'm petty as fuck. Let me passive aggressively type this about this person, not name them, and block them so they can't respond, and demand an apology from them. What? What? Sorry. I think that person's a fucking coward and a pussy, and I'm always going to fucking think that because that's not characteristics that you change. And I don't have to fucking like everybody that you people fucking like. Sorry, I just don't. Where's the law that says I got to fucking like everybody that you fucking like? Simply because we're on the same side of things. Who the fuck says I got to get along with the people that you tell me I got to fucking get along with? Like I'm fucking taking requests. I love when you're doing this and this and this, but I can't stand when you do this. Don't fucking watch. It's going to happen from once in a while. Once in a while, I'm going to get petty as fuck and I'm going to fucking talk about drama bullshit. It's going to happen sometimes. I reserve the right to do that. Why? Because I reserve the right to run my channel however the fuck I want to run my channel. It's my show. Watch it or don't. I simply focus on the people who I'm grateful for watching. And the way that I do that is I express myself honestly and say what's on my mind. I don't hold back. That's what my real supporters support me for. And that's what I will give them. Even if it's uncomfortable sometimes. You who feel like you get to pick and choose what I do that's good and what I don't do that's good, go fuck yourself. It's all bad. Fuck off. It all sucks. Fuck off. Don't watch. Get out of here. I'll make it real easy for you. It all sucks. This whole channel fucking sucks. Fuck off. But anyways, guys, I think this is a good time to go ahead and wrap this up. Sorry to leave things on a negative note, but it really wasn't negative. I think I was just clearing the air a little bit,
and making myself understandable here. That's I don't know how to make it any clearer for you guys. And I understand that there's new subscribers, and I understand that I run my channel unlike just about any fucking other channel that you follow. I get it, but I do. So either let that be why you watch the channel, or keep watching and be miserable, or fuck off. I mean, I don't know what else to tell you. I don't know what else to tell you. But I love you guys very much. You guys are absolutely fantastic. Please hit the like if you like this video, if you like this live. Hit the unlike if you don't like any of the content that I put out. And you want to be a hater. That's cool too. And make sure to subscribe if you're not subscribed already. And I'm grateful to all of you new subscribers. I hope that you enjoy the channel moving forward. And real quick, before I call it, I have one more thing that I want to share here. Give me 1 second. For those of you who are looking for something fun to watch, just some good old-fashioned comedy, nothing Karen Reed related, nothing true crime related, just fun shit. My friends Hannibal and Monty are live right now, people. I'm dropping the link to their live stream in the chat right now. Please go over and type Glarer Raid in the chat and go check them out. Give them a chance. I promise you, it's all wonderful. They are fantastic. So please make sure to go check out Hannibal and Monty. Very good friends of the Glarer. And there's, I know we're going right now, baby boy. We're going right now. I love you too. We're going right now. Guys, you're fantastic. Thank you guys for all the support. I really appreciate you guys. And we will do this again very soon, my friends.